Okay, we are back in session and we are ready for item 8.3, considering the Salina City Planning Commission's amended future land use map for Lowell Elementary School. Turn it over to Mr. Andrew.
Thank you, Mayor and Commissioners. You can give us feedback on whether you like the three-ring binder idea, but what we had was a situation where we didn't have a staple or anything that would fit around it, so we decided that that's what we did for the Planning Commission, is just put all the information in a binder for you, so you could flip back and forth as you need. But this evening you have two ordinances under item 8.3, and so you're having two recommendations come forward from the Salina City Planning Commission. The first is to amend the future land use map designation of the former Lowell Elementary School site from public, semi-public to urban residential. And the second recommendation would be that the school site be rezoned from its current R1 single family to Planned Development District R2. And just by way of background, the Unified School District number 305 made an announcement in 2002 that they were closing and consolidating a number of elementary schools, and their concern was that they didn't want to have shuttered, boarded up school buildings in the middle of neighborhoods, and they also didn't want to have a approach where they just took envelopes with sealed bids or low bids for the properties. They wanted to have some input into how the school buildings were reused. So they created a committee, and then they created a process where basically they reviewed from what the city's perspective might be a request for proposals, and they received individual proposals on each of the school sites, and then they had a committee review those and make recommendations. So on page 1 of your report, we have summarized those for you, and that occurred primarily in 2003 and 2004. And then in 2006, Hawthorne School and Parsons School were the last to be considered. But Roosevelt Lincoln Middle School was closed, and it was turned into an apartment complex for senior adults, now known as Pioneer President's Place. Hawthorne Elementary School was first occupied by some offices that occupied a portion of the existing school. Then the school building was replaced by the Heritage at Hawthorne apartments that are located up on North 9th Street on the site of the former school. The Bartlett Elementary School was closed and converted into an office building. It's the offices for Salina Homes and a number of other businesses. Franklin Elementary School was turned into a facility for Smoky Hill Education Service Center, and they conducted classes there and had office space there, and then later became the location of Cornerstone Academy, which is a private school. Lowell Elementary School there was a proposal received to convert it into a private Christian school, the Salina Christian Academy. Hageman Elementary School was retained by the school district and turned into offices and a training facility. And then Parsons Elementary School at Holmes and Country Club Road was purchased by Schooler Grain and converted from a school into an office building. So one of the school district's goals was to find users and uses that would be compatible with surrounding neighborhoods, and they formed a committee to look at the various proposals. The planning division worked closely with them to look at appropriate uses and zoning designations. And so a number of those conversions of the schools involved some sort of zoning change, and we've summarized those for you. The Roosevelt Lincoln Middle School was approved as a planned development district, R2.5. Hawthorne Elementary School was done through a planned development district and zoned R2.5. Bartlett Elementary School was done as a planned restricted business district. There was no change for Franklin or Lowell. Hageman Elementary School also turned into a planned development district, and Parsons Elementary School went from residential to planned commercial. So the theme that you're seeing there is that most of the zoning classifications were to planned districts or planned development districts, meaning that the zoning applications were accompanied by a specific development or redevelopment plan for the former school properties. And so just some background information on Lowell School. The site contains a little over 2 acres. The building footprint, just looking at the footprint the building occupies, is 12,784 square feet. The building itself covers 14% of the 2 acres. The current zoning is single-family residential. And the house, or the original building, was built in 1915 with an addition added in 1965. And in 1997, the property was historically designated as a conservation property. That designation means that the property may not, or the building cannot be demolished without review and approval by the Salina Heritage Commission. So back in 2004, we reviewed records and found where the representatives of city's DRT met with Salina Christian Academy to discuss their plans, and their plans was to have a non-denominational Christian school in the building for preschool through 6th grade. And they purchased the school building and grounds from USD 305 in March of 2004. They made some repairs and upgrades to the building, but they did not make any major modifications or additions to the building. The Christian Academy closed its doors on June 4th, 2019 at the end of the school year, and the property was put on the market. The Academy now has a prospective purchaser of the property who's interested in converting the use of the building from educational to residential use, specifically for multifamily housing. And based on its historic use and the zoning designation for schools throughout the community, the property was given an R1 zoning designation, which allows single-family but not multifamily housing. So in January of this year, an application was filed to rezone the building and grounds from R1 to R3, and the Planning Commission conducted a hearing on that on February 18th this year. And at the conclusion of the hearing, they approved a motion to direct the applicant to resubmit their application as a planned development district, which would allow the Planning Commission to review a specific development proposal and site development plan for the property. It was originally scheduled to be heard on March 17th, but all public meetings were canceled at that time. On June 2nd, the Planning Commission met to hear this item. The meeting was held in this room, but after the meeting there were concerns expressed about the audio and visual connections to that meeting, and so a new public hearing was scheduled for this application July 7th, 2020. That meeting was held at the Great Plains Manufacturing Convention Hall. And so the applicant voluntarily agreed to that rehearing, and that rehearing superseded all previous application action. And so if we look at the amended request, the original request was for straight R3 zoning. Instead of R3, the proposal is a reduction in density that would be allowed to R2, and that has a maximum density of 14.5 dwelling units per acre compared to 43 units per acre in an R3. And so the prospective buyer is interested in converting the existing school building into multifamily housing, and the specific Proposal is to convert the existing school building to 15 apartment units, to construct a parking lot onto the northeast and east of the school building, and retain the eastern portion of the property as open space set aside for future development. One thing we would note that's in your packet is a historic preservation consultant had been retained and did what's known as a preliminary site investigation questionnaire for Lowell School and submitted that to the State Historic Preservation Office. And that office has given Mr. Richardson and his consultant the go-ahead to proceed with a state and national register nomination. As opposed to a straight rezoning, as we looked at in the previous two cases, this is for a planned development district, and that allows you as a city commission to create a customized zoning district for a proposed development. And the submittal and development by the developer and approval by the Planning Commission and City Commission represents a firm commitment that actual development will follow the approved site development plan. So staff sometimes refers to a planned development district as what you see is what you get zoning, whereas in a straight zoning application, there's not necessarily a specific development plan that goes along with the zoning. And so it's a two-step process. We're at the preliminary stage, and a public hearing and recommendation by the Planning Commission is required. Approval by this body is also required. And if the request should be approved, then the applicant would have to come back with a detailed plan for phase 2 if that development occurs in the future. So what's before you this evening is a request for approval of a preliminary development plan for phase 1, which is a proposed 15-unit apartment project in the existing school building. No exterior changes to the school building are being proposed except for some minor repair and tuck pointing of the existing brick. So we've done our best to summarize in detail the various zoning ordinance requirements in the R1 compared to the R2 district. And among the factors you are to consider in your deliberations is the suitability of the site for development under the existing zoning. And this property zone R1, which is a fairly restrictive zoning classification that limits the adaptive reuse or redevelopment options for the school building and grounds. Under the current zoning, the only options would be another school, a church or group daycare center through a conditional use permit, or removal of the school building and redevelopment of the site for single-family homes or as a public park. One thing we noted again is that this is a designated heritage conservation property that's protected from demolition without review and approval by the Salina Heritage Commission. As we noted, this property was one of the schools selected for closure. The school district worked with the city to find a suitable buyer, and the identified buyer was Salina Christian Academy. Unfortunately, that reuse plan for the building was not successful long-term, and the Academy is attempting to market the existing building to a new owner and user, and their belief is that the R1 zoning limits potential reuses of the property. There has been some request from some surrounding properties owners and neighbors that this property be retained for public use as a playground or park. And we would note that this property is currently privately owned property. In order for it to be converted all or a portion to a park site, there would need to be either a public or not-for-profit entity to own and manage the park. The Salina Parks and Recreation Department has not expressed an interest in owning and managing a neighborhood park in this location. In the park plan, Sunset Park is identified as the neighborhood park serving this neighborhood, and it's about 1/2 mile from Lowell School. So when the initial application was submitted, staff's initial concern was that the R3 zoning was open-ended, and it would not allow the Planning Commission or City Commission to limit redevelopment to the existing school building. And so by modifying the application to a planned development district, that now allows you to review a specific redevelopment plan for the school site. There's been a lot of discussion about the character of the surrounding neighborhood. It is predominantly single-family residential, both owner-occupied and rental properties. The property is situated between two main arterial streets, South 9th and Santa Fe. And Republic Avenue serves as the main east-west street. The fire station number 2 is just to the southeast of this site, 1 block to the south. The surrounding neighborhood consists of owner-occupied and rental and single-family homes with a small scattering of duplexes. There's no R3 zoning in the vicinity, and that was one of staff's concerns about creating a standalone R3 district. There's a mix of R1 and R2 zoning in the vicinity, and by modifying the request to R2, the applicant is requesting a zoning classification and density that's more compatible with the surrounding area than the original R3 request. So except for one lot, the entire west side of Santa Fe between Republic and Beloit is zoned R2. So there would be, this could be viewed as an extension of that existing R2 zoned area. So in their review of this, the Planning Commission was charged with determining whether the requested planned development district zoning and the redevelopment plan would be compatible with the character of the surrounding neighborhood, the zoning and uses of nearby properties, and whether conversion of the school building would harm living conditions, value, or use of neighboring properties. The public utilities and services are a non-issue because this site has all the utilities and services needed. It's a fully developed, fully served area of the city. It's obviously in close proximity to fire station number 2, which brings us to streets and traffic. Republic Avenue is a collector street. Highland Avenue and Beloit are residential streets. The most recent traffic counts show Republic Avenue carrying 3,100 vehicles a day between Santa Fe and South 9th Street, and Highland carries about 600 vehicles per day north of Republic. We don't have any recorded traffic counts other than those two numbers. If we use the Institute of Transportation Engineers trip generation rates, they indicate that a single-family dwelling typically generates about 10 vehicle trips per dwelling unit per day. A low-rise apartment complex would generate about 7.3 vehicle trips per day per dwelling unit, and elementary schools have a wide variation, but their trips are either generated by student or by 1,000 square feet. So we have just provided for you some typical trip generation numbers based on assuming 100 students in the school and assuming single-family homes and assuming multifamily apartments. And because apartments have a lower trip generation rate than single-family homes, the trip generation from 15 apartments would actually be lower than trips generated if this were occupied by 14 new homes. I think, Mr. Hurst, if you could go back to the diagram for the intersection. There's a proposal to utilize an existing curb cut on Republic for the access into the parking lot. This curb cut is 72 feet east of the intersection, and the south leg of the intersection is another 75 feet over from that. The other thing you'll find on page 11 of your report is a table that shows the variable street widths and street classification of the different streets. So this section of Republic, you can see, is narrower than this segment. Over on this side, it's 38 feet. This right here is 27 feet. And then Highland is 37 and 34 feet. And this offset right here is a 41-foot offset, so that the intersection does not line up. City staff requested from the police department accident records to show what types of accidents were most common at this intersection, and the police department indicated that they had no reported accidents at this intersection in the last 3 years. Staff believes that traffic counts at the intersection should be similar or less based on the current redevelopment proposal, and comparing that to the operations of an elementary school. In terms of the comprehensive plan, we pointed out that this is shown as public, semi-public on the future land use plan, and that's because of its historic use as a public and private school. And when the comprehensive plan was adopted in 2010, it was being used as a school, so it was shown accordingly. So the Planning Commission held a hearing on this application on July 7th at the Tony's Pizza Event Center. Following presentation of staff report, comments from the owner's representative, Mr. Jeff Mays, comments from neighboring property owners, a presentation that was made by a neighboring property owner, Dan Peterson, presentation by the prospective purchaser, Brian Richardson, and additional public comment, the Planning Commission made 2 recommendations that are before you this evening. The first of those was the Planning Commission approved a motion 5-0 to recommend that the future land use map that Mr. Hers just had up there be amended to show the Lowell School site as a future residential land use area. In other words, to amend this to make it fit in with all the surrounding areas, and they felt that was justified to support its adaptive reuse for residential housing. The second recommendation they made was to recommend approval of an amendment to the zoning map to change the zoning classification of this property from R1 to PDD R2. And so I'm gonna slow it down a little bit and just try to kind of go through the conditions one by one on page 14 of your report, so that we can, if you could go to the development plan. Thank you, Destin. So the recommendation was that the development on this site, if the zoning is changed, would limit this to 15 apartment units here, and that future development here would be limited to single-family dwellings only. So there were some comments in the minutes and other things about multiple apartment buildings on the site. The recommendation from the Planning Commission was that the only development on the west half would be the conversion of this building, and the only development on these 3 lots here and these 3 lots here would be single-family dwellings, with the plan for that being brought back for review by the Planning Commission. The density limitations and bulk regulations would be from the R2 district, except that the planned development district would allow for a 14-foot building setback from Beloit Avenue. And as we discussed on some of the previous cases, part of the reason for doing that is to protect the investment of the property owner by making the 14-foot conforming if there was any damage or destruction to the building, and that wasn't there. They would have to set any new construction back 25 feet from Beloit, so this would allow any reconstruction to maintain the same setback. Their recommendation would allow 1 monument sign on Highland Avenue to identify the property. Their recommendation was that at least 30 off-street parking spaces be provided on the site, and the parking lot should be designed to have access from both Beloit and Republic, So this is going to be, would have to be modified on the final plan to show driveway access here and driveway access to the north. That the final plan for Phase 1 be submitted to and approved by the zoning administrator before there's a building permit. That the plan for Phase 1 would have to conform with the elements set out in the Plan Development District Ordinance. That they come back for final development approval for whatever occurs here. In other words, city staff would not issue any permits for any development there without a planning commission hearing and review, and that development of the site would be completed in substantial conformance with the approved site plan, landscape plan, and associated building elevation drawings, including exterior building materials. So on page 14 and 15, the Planning Commission set out its reasons for why it recommended approval of the request. And the first one was that the building is a historic resource and redevelopment of the building is preferable to vacancy or deterioration and demolition. Redevelopment into housing would be an adaptive reuse of an existing historic building. This provides additional housing units in an infill location. The current single-family zoning inhibits redevelopment of the existing building. The proposed redevelopment conforms with R2 density limitations. The redevelopment of the property with multifamily dwellings that adaptively reuse an existing building under a planned development district would not adversely affect the surrounding neighborhood. Public facilities and services are adequate. The site will be accessible from public streets that are adequate to carry the traffic, and the location of this site is consistent with the locational preferences for multifamily housing identified in the comprehensive plan. Also in your packet there is something identified as a protest petition, and under Kansas law, any zoning application is subject to a formal legal protest, and that protest, if timely filed, requires that any zoning change be approved by a supermajority. And in the case of Salina City Commission with 5 members, a supermajority is 4 affirmative votes. And Mr. Hers has on the screen the areas identified in blue are property owners who signed the petition. And so the requirement is that owners of 20% of the property within 200 feet sign the petition, and I think our calculations were that it was roughly 45%, owners of 45% of the areas signed the petition. So the first item of business is to consider changes to the land use plan. And so you could concur with the recommendation of the Planning Commission and approve Ordinance 20-11027 to amend the future land use designation from public to semi-public to urban residential. That would require 3 votes from the Commission. You could refer this application back to the Planning Commission for reconsideration, giving your reasons for disagreement, or you could overturn the recommendation of the Planning Commission and recommend that the future land use map not be changed. While this action would not preclude the applicant from converting the building to residential housing, by not amending the land use map, it would indicate a lack of support for the applicant's companion request to rezone the property. As to the zoning matter, you could concur with the findings and recommendation of the Planning Commission and approve Ordinance 20-11030, rezoning the property to PDD-R2. Because of the protest petition, that would require 4 affirmative votes. If you disagree with the recommendation of the Planning Commission, you could return this item to them together with your reasons for disagreement, and that would require 3 votes from commissioners. You could postpone consideration of this to a future meeting date to allow the applicant or staff to provide additional information. or you could overturn the recommendation of the Planning Commission and deny the application, provided that there are 4 votes in support of denial. You would also need to provide alternate findings in support of a denial that would be alternative to the Planning Commission's findings that they sent to you. Just a note about the preliminary development plan. It is linked to the ordinance rezoning this property. While it's linked, it can be reviewed and discussed, or elements of it can be discussed separately, and you could approve the site development plan as proposed. You could approve it subject to minor revisions, or you could send it back to the Planning Commission to allow major revisions to be made. So in your deliberations, one of the things we would encourage is to think about in your own minds how you feel about the change in zoning classification, and then if there are major changes or revisions that you'd like to see made to the plan or taken into consideration, then you might want to consider option 2 instead of option 4. If you think that the plan could be improved and you'd like some revision to be considered by the Planning Commission and applicant, then item 2 might be an option there to deal with site plan issues. But with that, we have an extensive number of attachments, and we've tried to show a lot of graphics on the screen. But if you have questions about the staff report or any attachments, we'll stand for those questions.
Prior to going into questions of the staff report, I would had a couple concerns that I want to have staff and legal counsel address, and that would be we had a question about some ex parte communication that had been sent to the commissioners, and then also there was some notices on a conflict of interest that I'd like to also be addressed. So
sure, I'll tackle the ex parte, and then I'll let Greg Bankson address the conflict of interest. As the staff report noted, the rezonings are a quasi-judicial matter, so in the interest of preserving due process, ex parte communications should be avoided so that everyone interested in the matter can hear all the information that you might receive to deliberate on it. So there were a number of emails that came into the collective city commission address that we make available and that is automatically distributed to each of you. And so staff inventoried all those, included those in the packet. So I think we have distributed all the emails that came into the city commission collective address so that all interested parties can be aware of them. I am aware of one email that came to that address this afternoon, shortly before the City Commission meeting, and I'll read that into the record here in a second. But then would also encourage you to disclose. One way to resolve ex parte communications is to disclose them, so that if you as an individual commissioner had an ex parte communication, you disclose it and you make the rest of your fellow commissioners aware of that. So the one email that I'm aware of that came in was from Lene Meyer. It was to the collective city commission address, and it reads, "Please, I ask you to take a look at a very big picture as you consider the rezoning the Lowell School area. I don't know all the details about needing more housing. There may be a need. I'm hearing that many of the people in the neighborhood have concerns. Please do not take the park away. This has been a special place in the neighborhood. Also, I hear concern about them making a parking lot, which can be a not so attractive setting. Please use the space in such a way that it does not create an unattractive view. I don't live in the area, but I have talked to those who do. Their thoughts and feelings deserve consideration. Please do not allow any personal connection with the developer influence your decision. I don't know if that is an issue, but if so, it shouldn't interfere with your vote. The decision needs to come from a very deep ethical place that will include a decision that affects all in our community. I cannot make the meeting today, so please pay attention to my concerns." So as I said, that is the only email that I'm aware of that came in after inclusion of the rest in the packet. And then I would encourage you, if you had any ex parte communications one direction or the other, or back and forth, now would be the time to disclose those.
Okay, we just wanted to get that out there since there were multiple emails sent out, so.
I'll defer to Mr. Bengtson on the conflict of interest question.
Thank you, Mayor and Commissioners, and if you wish to stop with questions, don't hesitate to stop me. The question that arose had to do with Planning Commissioner John Olson's participation in the initial hearing on June 2nd of this application by the Planning Commission. The question had to do with whether there was a conflict of interest by virtue of the relationship between Mr. Olson and Mr. Brian Richardson. While Salina Christian Academy is the applicant, as you know, in this matter, it had become apparently fairly well known that Mr. Richardson had an interest in the project or in the property. I don't personally know exactly, nor have I seen the documentation associated with that, but assuming that Mr. Richardson's interest is as a purchaser of the property, and again, I don't know the nature of the entity, whether individually or as an LLC or any other entity, that interest might be manifested. The question was raised as to the relationship between Mr. Olson and Mr. Richardson. The things that we do know from the public record related to that is that Mr. Richardson and Mr. Olson are both employees of the Occupational Performance Company, LLC. That entity is both of their employer. The added aspect is that, in that is an LLC, the public filings with the Kansas Secretary of State provide an indication of whomever has a 5% or greater ownership of capital in an LLC. And if you were to go to the Secretary of State's records on Occupational Performance Company, LLC, you would find that Mr. Richardson and Mr. Olson are both owners of more than 5% of the capital of that limited liability company. So when the matter was raised, it was referred to me, and I looked at the question and ultimately had a conversation with Mr. Olson about that. We ordinarily, of course, as we're told by the Attorney General, to first look to the question of whether there is a substantial interest, whether in this case, a member of the Planning Commission had, and Mr. Olson specifically, had a substantial interest in the party that had reason or was an interested party in this application. That would be Mr. Richardson's interest, whether that be individually or in an entity in which he had the controlling interest. Well, as you all are, I'm sure, aware, that substantial interest test has more to do with the relationship between the individual and the interested party. Mr. Olson, in talking with him, confirmed that he has no interest in Mr. Richardson's entity, which is the basis of Mr. Richardson's interest in this application. Does that make sense? So, there was not the matter of a statutory substantial interest at work. The next level of analysis goes to the question of whether there is a common law under Kansas case law a common law conflict of interest. And to get to the point, I won't elaborate on that too much, but in talking with Mr. Olson, I pointed out to him that there is unique language in the Planning Commission bylaws. That unique language speaks of whether or not the planning commissioner, when the member or his or her employer, business partner, associate, or any person related to him by her or her by blood or marriage has a recognizable financial interest in the outcome. Regardless of the nature of the entity, we know that Mr. Richardson has a recognizable financial interest in the outcome. And in this case, although it is not in the entity that has the interest in the outcome, with this language, under the Planning Commission bylaws, I advise Mr. Olson that, in my opinion, that language was seeking to reach any business partnership or business association type relationship. So that under that unique language, the fact that Mr. Richardson and Mr. Olson were both owners in the entirely separate entity, but yet co-owners of Occupational Performance Company, Inc., that relationship fell within that language that is unique to the Planning Commission bylaws. We also, as you know from Mr. Andrews' report, had the unique circumstance precipitated by the need for the rehearing by virtue of the technical difficulties associated with the June 2nd Planning Commission meeting. My conversation, of course, with Mr. Olson was after that meeting and prior to the rescheduled public hearing that occurred on July 7th. It would be my understanding that if you all were faced with the matter of having the Planning Commission recommendation from the June 2nd, the first public hearing, and this matter of the conflict was raised, either you or as the City Commission and the ultimate body responsible for deciding this question, or if it had even been raised and it was a matter of a Kansas court addressing what to do in that circumstance, that would most likely take the form of one of two actions: either simply disqualifying Mr. Olson's vote in that action taken as a result of the first public hearing, or, depending upon the circumstances, potentially even asking the Planning Commission to reconsider the matter without Mr. Olson's participation. And we know the circumstances that in this particular case precipitated the need for the rehearing on July 7th. Mr. Olson did not participate in the reconsideration under the July 7th hearing, was not present actually during those deliberations. By virtue of that, it would be my understanding that what has transpired, despite all of the inconvenience associated with the need for the rehearing, it did present the opportunity for the Planning Commission to rehear the matter and provide you with their recommendation without Mr. Olson's participation. With that, it would seem that you now have before you the responsibility, as you normally do, to consider the application on its merits and with the benefit of the recommendation, in which Mr. Olson did not participate. And if that all makes sense, that was the way it transpired.
I've got a few follow-up questions, if that's all right, on this particular
That's sort of
matter. First of all, I just would like to know if council and city manager Scragg watched the June 2nd meeting where Commissioner Olson participated.
I did.
Okay. I watched it last night, and I think it's fair to characterize it as Commissioner Olson led that conversation. Commissioner Olson made both of the motions in the affirmative for this development. And by virtue of Commissioner Olson's action on that date, how do we unring the bell, first of all? He was there advocating. He was there making the motions. How do we unring that bell for the second meeting? I mean, because it's all very well and good to say, we're going to reset. How do you know that everybody did reset, or if they were thinking back to the advocacy that he had at the June meeting? I mean, we can't, can we?
There's a lot there that I, of course, don't know. I don't know that any of us know, other than the planning commissioners possibly, that were in that
Right.
role in those two meetings. I certainly understand that. My point was, whether this be what would have been the discretion of the city commission, or even if it were before a Kansas court, the way I would understand a court to attempt, in response to your point, I think I can understand why under these circumstances the court would not have said, well, we'll just not count his vote and take the rest of, whatever impact that had. I could see how this would be a case where a court would potentially say, no, we need to go back and it needs to be reheard without Mr. Olson's participation. I don't know that there's any more that can be done than that.
Something that wasn't clear to me was the reason for his non-participation made clear at the subsequent meeting. Because in the case of a court case, I'm assuming that you'd have some judicial guidelines saying, okay, here are the instructions from the court. You have to totally not regard anything that the commissioner who participated in said, because he has a recognized conflict of interest. Were similar instructions given to the Planning Commission prior to the July meeting?
No.
Okay, and so there wasn't an acknowledgement of why Commissioner Olson was not present. It's just the fact on the ground was he was not present. Is that correct?
I think they were
Well, there
advised he
was-
was recusing himself.
yes, there was-
Instructions that you asked about were not provided.
Yeah, Mr. Andrew can correct me, but as I recall, the description was given that he was not present on the basis of
conflict.
recusing, and I'm looking to Mr. Andrew to make sure my recollection is correct.
Beginning of the item at the Planning Commission, I announced that Mr. Olson was recusing himself from that item and had chosen to recuse himself by not attending the meeting due to the fact that he had a recognized conflict of interest. That was reported to the Planning Commission.
Okay.
And I don't know if it helps, but with respect to unringing the bell, we had need to conduct another item for the Planning Commission to reconsider another item due to technical difficulties, and they ultimately did reach a different conclusion on that item.
Just a couple more questions. I know that one of this board's point of emphasis was an increased emphasis on board orientation with a particular focus on reviewing our ethics policy with all commissioners. Obviously, there are some commissions where that is particularly important, the Planning Commission probably being the most important. When was the last time that there was a board orientation or a presentation and an explanation on our ethics policy given to the Planning Commission? Did Mr. Olson have the benefit of that or not?
I would have to review the minutes of that meeting, but in September, the Planning Commission, the Board of Zoning Appeals, the Heritage Commission, and the Downtown Design Review Board all have their annual business meetings. And preceding the annual business meeting, each of those boards has an orientation and training, and that occurs at their September meeting. And that occurred in September 2019 with the Planning Commission, the Board of Zoning Appeals, the Design Review Board, and the Heritage Commission. And those are the planning boards that staff is responsible for. And that includes an overview of their roles and responsibilities. It includes an overview of the ethics policy. It also results in the bylaws and ethics policy, a copy of those being presented to each of the commission members.
And it would be possible to determine whether or not Commissioner Olson had been in attendance at that, I'm assuming, so
It would be
hopefully-
based on attendance at that meeting.
Okay, thank you. How was city staff made aware of Mr. Olson's potential conflict of interest?
I was made aware by Ms. Jacqueline Cairo, who I was engaged in a phone conversation with.
Okay, so,
She brought it to my attention that some of the neighbors had that perception, and I told her that, I asked her what the basis of that was. She gave it to me. I did some independent research of my own and pulled some information together and contacted Mr. Bankston to get his guidance on whether that rose to the level of a conflict.
well, thank you for taking her concerns seriously, and thank you for following up on it. But I do just want to confirm, Commissioner Olson did not voluntarily divulge this information. It was incumbent upon a member of the Lowell School neighborhood group that had to bring this and seek redress from the city. It was not Commissioner Olson saying, you know what, I've thought about this, I'm not comfortable with my participation. This was something that actually had to be reported to the city, and it was not volunteered by Commissioner Olson.
No, it was brought to my attention by Jacqueline Cairo, it wasn't discovered on my own, and it wasn't, we have to rely on board members and commission members to come with us with questions or concerns. So you are correct that that was brought to my attention, and when I did some preliminary research, I contacted Mr. Bankston and provided the information to him to get some guidance.
Thank you.
Has he been scheduled to retake that part of the orientation?
Well, in September of this year, what we do is, because we have new board appointments usually occurring at the end of August, each of our planning boards has their annual business meeting at which they elect officers and take care of other business, and we use that. We essentially have a study session before that meeting in the room next door, and we do training, and we do orientation for new members and refreshers for current members. And so we'll be doing that again in September.
The annual meeting took place on September 17th of 2019, and Commissioner Olson was absent.
I'm sorry, you said it was absent?
Correct.
Given the fact that we have used the ethics policy in the past as a means to sanction members of the commission, if sanctions were within the purview, would it be within the Planning Commission's purview, or would it be within this governing body's purview to pursue a reprimand?
That's under the policy, that is the governing body's discretion.
So the conflict in question is not part of the city commission's ethics policy, it's part of the planning commission bylaws?
That is true.
But the ethics policy sets out any sort of consequences for that, and those fall within, if it is a city employee, it would be the city manager. If it's a board or commission member, then that would be within the discretion of the governing body.
Thank you. And the reason I am harping on this for so long, and I'm really grinding on Commissioner Olson here, is because by virtue of his actions, any decision that we render here today is going to be suspect. It is, and that's the fact, and we have to deal with it, and we have to still go ahead and make the best decision that we can in our judgment. But, you know, this was always going to be a difficult discussion to have, and when you started out and immediately the neighborhood has no reason to trust the city at this point, I just could not be more disappointed in Commissioner Olson's failure to realize at the very least that it was the appearance of a conflict of interest. So at any rate, with that being said, well, I guess we'll just have to discuss amongst ourselves later about how we'd like to proceed if we do.
Recognizing that concern, I think the fact that we ended up having a hearing, a second hearing, without him participating, positions us, as Mr. Bankson described, in the best position we can be. Additionally, then, you, as the governing body, are certainly an independent body. Staff has tried to provide you the full record of this matter so that you are fully informed and can make an independent and objective decision this evening.
Thank you.
If I might chime in for a minute, I would echo some of Commissioner Hodges' comments. I was very disappointed to see this occur, and I'm disappointed in the development group as well. I think that they both had a responsibility here, and Mr. Bankston, I really do not care if the same entity is involved or not. When you have a close business relationship with somebody and you're sitting on a board that is considering a request from that person, you know, it's not rocket science. It's pretty basic understanding of public policy that that's inappropriate. And so I'm kind of, you know, I am concerned about it. And as far as I'm concerned, my part in this is I'm going to try to disregard any recommendation from the Planning Commission and proceed on the basis of what we have in our packet and what we hear tonight. Because I just, you know, it's how do you unring the bell? That's a good question.
Well, and, you know, when you try to forget what you've heard, at least you know, my tendency would be to go to the second meeting saying, well, if I hear anything different that'll change my mind, then I'll change my mind. But I did most of my thinking at the first meeting. So it's we're like in the, you know, the Perry Mason TV shows, if you'll indulge that comparison. You know, he'll say something that he knows is going to get thrown out, but the jury's heard it. And, you know, that was his intention all along. I did one question for I'm looking at the pictures of the school. Part of this school doesn't look terribly historic. It looks like it was added on many decades after the original building. Is like that part to the left, well, that picture that you just had up.
There's the original 1915 school, and then there was a 1965 addition to the school.
Right. Now, I'm assuming just the original 15 part is the historic part? I mean, it's not, you know, an official national
The
register,
designation doesn't distinguish between parts, it just designates the entire building.
So not even the new part could be torn down without the
Not even the new part.
Heritage.
There may be less concern about tearing down the new part, just as a portion of the St. John's Hospital was torn down, but that portion was still reviewed by the Heritage Commission before it was torn down.
Right now, does it, having even the citywide historic designation, make it difficult to change the future use of that property? And that building's only going to be usable for obviously so many purposes. Does that historic designation change how you'd approach the future land use? I mean, let alone the zoning, but the future land use decision?
Well, as we indicated in our report, there's what's called a preliminary site investigation questionnaire that was prepared by a preservation consultant at the behest of Mr. Richardson. That request was sent to the State Historic Preservation Office. They reviewed it and gave the go-ahead for a nomination to put this property on the state and national register. To move ahead with that, if that should be approved, then that would allow any redeveloper of the property to access historic tax credits to assist with the redevelopment of the property. In the case of the Roosevelt Lincoln Middle School, that property is on the National Register of Historic Places, and by virtue of that, the redeveloper of Roosevelt Lincoln was able to use historic tax credits to help finance that redevelopment of the property. And so the historic designation becomes significant just from the standpoint that if it is designated as a state and national register property, that would enable any redeveloper to utilize tax credits to assist with financing the redevelopment.
But it doesn't particularly restrict the future use of the building?
It has nothing to do with the use, it only deals with demolition. So the Heritage Commission wouldn't be reviewing modifications or changing windows or things like that. It would the only thing that the current designation deals with is that the building can't be demolished or removed from the site without a hearing before the Planning Commission, or Heritage Commission, excuse me.
Okay, thank you.
Commissioners, I apologize, but if I could double back, I appreciate Commissioner Franz's description of intending to make his decision independently based on the information this evening. If any of you are unable to do that, or if you intend to factor into your decision the conflict and your dissatisfaction with that, I think that rises to the level of needing to have an executive session. If not, I think we're fine, but if...
But in terms of disregarding the Planning Commission's?
My comment would be, usually, our job as a commission is to ratify the Planning Commission's recommendation. There seems to be some issue. Do we as a commission want to go into more detail than I need direction as to how we want staff and the developer to proceed and those that are here in opposition. How do we wish to proceed tonight?
I would suggest, because obviously we can't discuss, but we would discuss in an executive session out here to see if we want to go in. But would 5 minutes be enough time?
Sure.
I'd suggest we move into recess into an executive session to...
We've got to wait for our
I think I'd
executive
memorize
session
it by now.
scribe.
To discuss, are you, write that out for me?
Well,
Okay, I'd appreciate it if you did.
is it fair to say that the subject would be the Planning Commission recommendation?
Yes.
Is that a fair statement to say?
And you better make it 10 just to be safe. And by the time we get there and seated and...
There is a blank that if you want to refer to the Planning Commission recommendation in the blank.
Okay.
The rest of it should be.
All right. I move the City Commission recess into the executive session for 10 minutes to discuss the subject of legal considerations relating to the Planning Commission decision regarding the formal Lowell Elementary School site rezoning application with legal counsel based upon the need for consultation with an attorney for the public body which would be deemed privileged in the attorney-client relationship pursuant to KSA 75-4319B2. The open meeting will resume in this room at 8:01.
Does this really rise to the level of excluding the public?
Do we have a second?
Second.
We have a motion and a second to move into executive session. All those in favor?
Aye.
Aye. Opposed?
Nay.
Okay, well, that's 4-1.
Are we going
Yeah, we'll
in
meet in 105 and we'll return here.
Okay, we are back in session. I will turn it over to Mr. Bingston.
Thank you, Mayor and Commissioners, and as for the benefit of those that are here and those that might be watching, what you just saw transpire was a situation that we don't run into very often, but when we do, we have to proceed in a certain manner. Mr. Scragg was aware of potentially a legal consideration that possibly warranted advice from me as legal counsel to the governing body. It is not for Mr. Scragg nor me to try to anticipate what the governing body views as being privileged or not. I knew that the matter was subject to legal privilege, privileged communication, if that's the way the governing body wanted to maintain it. We've had the conversation that we needed to have, and in the course of that conversation, the governing body has advised me that it is with their permission that I can now relate publicly why it was that we went back into a closed executive session to have that privileged conversation. It boiled down to this. We understand, and you've heard concerns expressed by governing body members as to the potential impact of the conflict of interest in terms of the Planning Commission's consideration and ultimate recommendation on the matter. The legal point that we needed to make sure everyone understood is that as each member of the governing body considers the application, while the aspects of the conflict and any potential results or ramifications from Mr. Olson's participation in the first hearing in the minds of the governing body or any members of the governing body may have influenced that ultimate recommendation. While it is their prerogative to evaluate the Planning Commission's recommendation as they see fit, we do have to be also watchful that the Planning Commission recommendation is one of the factors that the governing body is to take into consideration as they ultimately decide this matter. One of a number of factors. The ultimate point was that we be sure that their consideration of the matter on the merits is just that, and that any effect that may or may not have been had on the Planning Commission's recommendation by the conflict of interest problem or concern not be overriding in terms of their consideration of the matter on the merits. That was the essence of our conversation, and so hopefully you understand why we had to go back, and that Mr. Scragg and I had a clear understanding of the governing body's thought on whether or not that was appropriate for public discussion.
Okay, thank you, Mr. Bingson. Okay, I think Mr. Andrew, you are up here. Do we have any direct questions for Mr. Andrew on the blue sheet?
See if there were any questions about the recommendations or findings of the Planning Commission as to the two matters, or if there's any drawings or anything that you would want to view again. But the two ordinances that are before you as relates to the future land use map and the zoning map, those ordinances are drafted so as to reflect the recommendation of the Planning Commission at their July 7 meeting. So the ordinance 2011-030 incorporates the conditions recommended by the Planning Commission and those findings as well. So just wanted to clarify that the two ordinances that are before you for consideration were prepared based on the July 7th recommendations of the Planning Commission.
Are we having discussions and questions on these two issues separately, one after the other, or are we combining? I was assuming we were doing just the land use first and then come back with questions for the zoning.
You can certainly do that. That's the order the actions would need to be taken.
And the reason
in.
I asked that they're two very different issues for me.
And
Most of my questions were for the zoning, not the land use.
Okay, so are
I'm just
Take them.
asking.
Okay.
If we're doing them all together, then I'm not finished with questions. But if we're doing them separately, then
I guess we could do
They
the,
plan to take public comment all at one time or between
or
each?
between each, that's the question.
You know, I think that, they are different issues, but I think that they are related enough to where we ought to consider them together.
Together, that's
Because they
kinda how I
do touch each
pictured
other
that.
in many ways.
So, okay. Okay.
You know, I'm okay with considering them together anyway.
We'll vote separately, obviously, but consider them.
okay. Well, then I should ask more questions now. Then.
Okay.
All right. And the way I'm looking at this is because I don't live in this area, and I realize there are a lot of neighborhood concerns. So, I have to look at this as if Meadow Lark Ridge School was in the same situation. How would I respond to it as a true neighbor? To what extent, generally, I'm going to use the term city in generic sense. Is the city obligated to change zoning to help someone sell a property that, because of its zoning designation, is difficult to sell? Is there any obligation for economic development, any obligation otherwise to, if the major reason for the change is to stimulate or allow a sale of the property, is that a bona fide
You are
reason?
under no obligation whatsoever to change the zoning classification of the property. The justification that has been put forward is that the current residential single-family designation limits the potential reuses of the building and property. If you look at the list of the schools that were converted to other uses following their closure, only Franklin and Lowell, because they were essentially used for very similar purposes and units, didn't require some form of rezoning to support the change of use. So
Is that done before they were sold or after?
they were done, I'm not positive in every case, but it is, in my experience, it is not unusual at all for, and I actually recommend when I visit people to use what we call contingent contracts. So for example, there was a property owner that owned the southeast corner of 9th and Schilling, which is presently the location of a Lowe's home improvement store. That owner entered into a contract with some developers from Dallas, Texas, And the contract specified that the contract would not close unless the city granted all land use approvals that the purchaser was seeking. So it is fairly common for prospective purchasers to have a contract that's contingent on some zoning change being made. So if we use Bartlett School as an example, there was a proposal to purchase Bartlett School and turn it into an office building. Had the city declined to change the zoning classification of Bartlett School to allow it to be a business and professional office building, that contract would not have been executed because the zoning would have prohibited the conversion of Bartlett School to an office building. So the contract to purchase Bartlett School from the school district was contingent on the city agreeing to grant a zoning change. And I don't know any of the particulars in this case as far as contracts or contingencies or anything, but it is not unusual. But just because there's a contingency in the contract does not obligate you to change the zoning. It's just simply that the R1 single-family district is among the most limited zoning districts that we have, so the range of uses that you can put a closed school building to is very limited in an R1 district compared to other districts. So you cannot take this building and turn it into multifamily housing under the current zoning. So the planned development district R2 was viewed by staff as the best vehicle to go from R1 to something that could be, that there could be assurances that what was proposed is what would actually happen to the building.
So with respect to your question about criteria in effect, by our ordinance, and it's covered in the staff report, but there are 5 criteria called out. The first of those being the character of the neighborhood and the uses and zoning of a nearby property. The second one is the suitability of the subject property for development with uses permitted under existing zoning. And so that kind of gets to Mr. Andrews' point about redevelopment under R1.
All right. So that's a gut decision we have to make regarding the likelihood that the property would ever be used for anything under its current zoning.
I mean, part of what you should look at is whether you think if this stays zoned R1, visualize in your minds what uses you see the building being able to put to if the zoning is not changed.
Well, not so much the zoning, the property. I mean, the building can be knocked down if you get permission, but it's the property that gets zoned.
Correct. You're not zoning the building, you are zoning the property.
As far as the traffic counts for an multifamily housing, how does that compare with what's calculated for a school that's being actively used?
Well, the main problems with schools is that schools usually have a peak traffic associated with them, which associates with the opening and closing of school, and so there's a wide variation. But what we used was if you had an elementary school with 100 students, that would generate 130 vehicles a day, but depending on other factors, it could be as much as 300 some vehicles a day. But if you had an elementary school with 300 students, then you're talking about 390 vehicle trips per day, and that's going to be primarily around the opening and closing of school, and then the periods during midday are relatively quiet, whereas in a residential setting, there's still a lot of rush hour related traffic, but in a residential setting, you're not going to have the peak traffic flows like you do with the opening and closing of the school day.
And I guess schools are quieter on weekends.
If I might, because what I have is very related to that. You said a school with 100 students. Do we know how many students Lowell had attending when it was open as a public school?
The only figure that I could find was that in the latter years, the way the school district operated Franklin and Lowell is that they divided it between the grades, and the only number I could find was that combined Franklin and Lowell had 333 students and 25 faculty.
Okay.
But that's taking the two campuses when it was divided up by grade level.
Yeah, just based on the number of classrooms, if there were 20 students per classroom at just Lowell now, that would calculate to somewhere between 200 and 250 students, teachers, staff at that location at that time. So that's probably pretty close.
With respect to traffic counts, if it's helpful, the Kansas Department of Transportation published traffic counts in 2018, and they identified multiple blocks on Republic, but the block of Republic immediately west of Santa Fe, so the block in question, they reported as 3,115. The block immediately east of Santa Fe, so one block further east, they reported as 3,915. So there's a 800 car per day traffic count difference in those two blocks.
Okay.
What year was that?
2018.
2018. So that would be, was the Christian Academy operating at that time?
Christian Academy closed its doors in the spring of 2019.
Okay.
But I can't speak to enrollment or declining
Right.
enrollment or any of those things. That would be something that Mr. Reynolds, the owner's representative, is here, and he might be able to answer that in terms of enrollment. But the closure occurred in the spring of 2019.
Okay, there's been reference to the area being used as a park, and there are no true neighborhood parks or pocket parks in this immediate facility. But this has been private property for more than 10 years. Has any part of this property been used as a de facto neighborhood playground, even though it's been private property?
I would let Mr. Reynolds speak to that. I think there was a period of time, the change in ownership occurred in 2004, so we're roughly 16 years in of private property ownership, and there was a period in the recent past where, due to some damage and concerns about the school, the playground area was locked and not made available to neighbors to access. If it was used by neighbors ahead of that time, it was done just by the school as being a good neighbor. But if you look at the park's master plan, the designated school or designated park for this neighborhood area is considered to be Sunset Park,
Which is
which
good
is
long
a half mile
6
to the
blocks
west on Republic.
with 9th Street in between. Yeah.
But in terms of, if we look at the city in terms of park service areas, this neighborhood would be considered in the Sunset Park service area.
Okay. I like old buildings, and particularly old sturdy ones, and if you can reuse them, it's great. I think parking can be hidden with shrubbery and stuff. But I'm concerned that 184 neighbors signed a petition saying that they didn't like this project. And if you look at the immediate neighborhood around this school, there's a fair amount of opposition, and probably not necessarily all for the same reason. To what extent can the unplanned property, I mean, to what extent can restrictions be put on what happens to that early on, if it were to
You're
go
talking
through?
about the future development area?
Future development, yeah.
So the planning commission did put restrictions on it, And the only difference is it's basically zoned the same that it is now. The difference being is that if it stayed zoned R1, someone could come in and obtain a building permit to build a house, a house, a house, a house, a house, and a house. But under the Planning Commission's recommendation, whether it's this developer or future developer would have to submit their plans for what they wanted to build there, and the Planning Commission would look at the design, the number of stories, whether it was on a full lot or a lot and a half, and the Planning Commission would have the discretion to approve or disapprove that plan, and the neighbors would have an opportunity to see what was proposed to be built there, as opposed to if it was left zoned R1, then the neighbors would not get to see what was built there.
Right, and and the neighborhood was characterized as a mixture of multifamily and single-family dwellings.
There are a number of, and much of this dates to the time when the Schilling Air Force Base was here, and there were a number of conversions of homes on Santa Fe from single-family to having multiple units put in them, some of them done legally, some of them done surreptitiously, but the homes that are not single-family only are primarily concentrated on Santa Fe, not on Highland.
Right, so then, if we're going to, one of those criteria is the general, and I'm paraphrasing, the character of the neighborhood. The character of this neighborhood would be best described as single-family. I'm talking about...
It is predominantly single-family.
Single-family.
Yes.
Housing.
Recognizing that the two-story school building itself has been present in the neighborhood since 1915. So.
Right, and most residential neighborhoods, at least in this country historically, have an elementary school somewhere in there, but that's just an accepted part of, well, it's a desired part of the neighborhood, actually.
But you will not find apartment buildings or anything of that nature in the immediate neighborhood vicinity.
Okay. I may have one more, but I'll yield the floor. I think I'm done now. Go ahead.
I was going to follow up on one of Commissioner Davis's questions in terms of looking back at the Planning Commission's actions on the undeveloped area, Phase 2 or whatever you want to call it, that doesn't include the future development area indicated in green. The Planning Commission, I just wanted to confirm this. So they opted to do an R2 PDD or a PDD R2 as opposed to just a straight R1 zoning, because it would then require a plan to be brought back that the Planning Commission, the City Commission, and the neighbors could all comment on?
They were given two alternatives, which were discussed in detail at the meeting and discussed by the Planning Commissioners at great length. And one of the alternatives that they were given was to create a planned development district that basically went to this line here and create a planned development district just here and leave this as it is, which is zoned R1. They looked at that as an option. The result of that option would be that the prospective developer or a future developer or a future owner could take this lot, this lot, this lot, this lot, this lot, this lot, submit a building permit application to the city and receive review of that and go out and build houses, 1-story, 2-story, garage, no garage, and that would just be subject to an administrative building permit. The other option was to take this entire 2-acre site and make it, the entire site, a planned development district, and that way the Phase 2 future development area, whatever came forward to be built here, which the Planning Commission said they only want to see single family only, but they would review those plans as to whether they're 1-story, 2-story, 20 feet tall, 14 feet tall, what their exterior materials are, whether they're garages or no garages. Those would, one, be reviewed by the Planning Commission, but two, those plans that were proposed for the future development area, since they're unknown at this time, there would be notification of neighboring property owners and an opportunity to review those plans before development occurred, as opposed to just an administrative building permit. So that's what their thinking was that it would give an opportunity for the neighborhood to see what was proposed there, as opposed to having an administrative process.
And so under every PDD, there has to be an underlying zoning, whether that's R2, R3, I mean, but there's not an R1 PDD, correct?
There could be, and that I mean, it was difficult to get here, but that is a potential option. The Planning Commission simply addressed it by saying, we'll call this Planned Development District R2, but we'll limit the uses to single family only. And so they discussed at length whether to allow duplexes here or duplexes here, and they decided as a commission that limiting this to single family dwellings only would be more compatible with the surrounding neighborhood than allowing for duplexes. So that wasn't known ahead of time, and it was given as an option, and they recommended it be lit. So in theory, you could modify this so that this part was Planned Development District R2 and this was PDD R1. It's just that their recommendation was to make it all one classification with development limited to single family on the eastern portion.
And even though they made that, like, that recommendation, the underlying zoning is R2, so let's say in 5 years, 10 years, whatever, down the road, if Mr. Richardson sells the property and it's a new developer or whatever, and they want to come in and do duplexes, you've got the underlying zoning there, even though the PDD recommendation
You
is
do
for
not.
single-family homes, or does that?
No.
That sticks?
That sticks.
Okay.
The single-family dwelling limitation sticks. So
Okay.
if in 5 years somebody wants to build duplexes, notwithstanding that the map says PDD R2, the ordinance says single-family dwellings only. And so if somebody wants to build duplexes, they're coming right back here with a rezoning application to make it, to add two-family dwellings to the list of permitted uses, because as recommended by the Planning Commission, it's limited to single-family only.
So wouldn't it be cleaner to just call it PDD R1 from the beginning?
It could be, yes, that'd be within your discretion. It's just, we didn't know. We had an application for PDD R2, and no one knew till the Planning Commission deliberated how supportive they were of duplexes versus single-family, and they unanimously agreed that it should be limited to single-family only. But the application was for Planned Development District R2, but the ordinance could be modified to have these lots be Planned Development District R1 if you so desire. It's the same result, but I would agree that if somebody was looking at a zoning map and it said PDD R1, that would be more instructive than if they looked at the map and it said PDD R2. And then we tell them that even though it says R2, it really means single family only. So yes, that is an option to have it Planned Development District with mixed R2 and R1.
On Republic, on the north side of Republic, will parking still be allowed on that north side of the narrow stretch of Republic, the on-street parking?
There isn't really a reason to change that. From staff's perspective, a lot of the peak associated traffic with the school or the historic school use is going to be less. But the way the street is posted now is for parking on the north, no parking on the south, and there isn't a great reason to think that that would need to change.
I wanted to confirm because right now, those property owners are accustomed to being able to access on-street parking, and I just wanted to make sure that that would continue for their use, and
Many of their driveways are very short and very
Right.
tight, and it's actually difficult to get in some of them on the north side.
right. I think that's about it. I'm sure that there's going to be, but the present plan does call for the 2 entrances and exits, one on,
Yes,
On-
and the other thing
on
we pointed
Republic
out
and
is
one
that
on
although this looks like it's paved, and it is, that's playground paving, and that's not going to be sufficient to support vehicles, so there'll probably be reconstruction of an entire new parking lot, but the recommendation from the Planning Commission is that there be a curb cut on Republic and the parking lot be connected to Beloit.
Beloit.
And the belief being that of the path of least resistance, that eventually people will decide mostly to enter and exit on Beloit, but that will also allow for pass-through traffic. It's better for fire apparatus and ambulances and others to be able to go circulate through as opposed to having to circulate back. So the recommendation was to modify the parking plan so that there was a curb cut here.
When we're discussing that, was that originally that way, or is that a modification that's been made to the original plan that was submitted?
Well, the original plan just focused the parking
Right.
up here, and this curb cut that's there is not really, it was only used for delivery drivers and for people that were delivering food for the lunch program, but it wasn't, nobody was parking here. This isn't a parking lot. Cars weren't driving in and out. There was an occasional delivery, and vehicles used it for the school lunch deliveries, but it's not, this is not a very active curb cut.
But what I'm saying is, has the Beloit curb cut always been a part of the application?
It was not part of the application. It was not proposed by the applicant. It was recommended by, that came from the Planning Commission, not the applicant.
Right, but that's something that's been added at the request of the Planning Commission.
That
then.
is correct.
Okay,
That
thank
was
you.
part of their recommendation.
We know that the most of the area is multifamily housing. Do we know how much of it is rental?
There's a map in your packet.
I have that. The question, is the green, is that rentals, or is that, I couldn't tell. There wasn't a color coding on this.
Supposedly, the highlighted areas are supposed to be rental, but that map was furnished by Mr. Mays, and I'll let him address that. He submitted that as part of their application, and it was based on a comparison with the physical owner's address versus the physical address of the property, and I think he'd be in the best position to explain that.
Does that map separate single from multi, or just owner occupied
It's
versus
just
rental?
owner occupied versus rental, and that's based on, when we do our property owner mailings, since we're responsible to mail to property owners, we'll often have a situation where the property owner's physical address is somewhere else than the house that's in proximity.
Right, yeah,
So
that part I understand, but these are all single-family home, or the majority of them are.
There's a few on
Yeah.
Santa Fe that have been divided
Right,
into
right.
more than single family, but these are primarily single family dwellings, and the intent of the map was to show those properties that appear to be rental residential as opposed to owner-occupied residential.
And yet we're adding rentals with this application. Do we know about the presentation of the petition, and was there any written information given to the people asked to sign? Do we know anything about how that was presented to them? Were they promised a park, or?
The people that circulated the protest petition are here at the meeting, and so they can explain that. What we did as a staff is that we met with them and provided technical assistance for them, and our goal is to make sure that there's a desire to have a protest petition, that we assist the protesters with meeting all the legal requirements, so that we don't have a petition that's not valid because of some technical reason. But what people were told who signed the petition, that would best be addressed to the people who circulated it, who are here at today's meeting.
When I was a planning commissioner, the comp plan was kind of my guide, and we talked a lot then. We talked about it a lot up here as well, about density and urban improvements, housing inventory, core reinvestment, readaptive reuse, traffic patterns, and I'm going to just ask you the question, do you think that that's also a guide for our planning commission now, that they have those thoughts? Considering this proposal is consistent with the prior property conversions and is probably going to raise property values, I would imagine they were thinking in that bigger context.
Well, there was some comments made by planning commissioners about opportunities for infill development and adaptive reuse, and I think the concern that some planning commissioners had and that planning staff has is a concern about having a building that sits empty, and a building that sits empty is, in our experience, going to deteriorate over time by being empty. And so there's always, that was the main interest that the school district had when they put these properties up for sale, was that there be good adaptive reuse of the property. And Salina Christian Academy had a 15-year or 14-year run there, but that has come to an end. So now we're faced with the prospect of figuring out what is the best adaptive reuse, if any, of this existing building.
Well, the list of readapted is impressive. I think there's had some great success there. I would hate to think that this might go the road of St. John's Hospital.
Commissioner Franz, any questions?
Yeah, I will admit I am concerned about the narrowness of Republic and the access onto Republic. We have 15 units here that will be accessing it. If you put 3 more residences in there with 3 more driveways onto Republic, that strikes me as a lot of load. I am glad to see that they've modified the request to allow access to Beloit, which is better, and until you said something about fire access and being able to drive through, I was pretty well set that we need to close the access on the Republic side. I'm reconsidering that.
That is something that lies within your discretion. But
as far as the future use of the future area, they say 6 single-family residences. Is it possible to designate those so that the access is up the center instead of the streets on either side, or at least on the Republic side, so those do not add those 3 additional driveways on the south edge of Republic Avenue through that narrow section?
yeah, Dustin, if you could go back to the aerial photo. One of our pieces of research was to look at, and this is technically, it is a alley that's open and never been vacated, but for various reasons, many of these owners have crept into the alley, and so this alley, while it's public right-of-way owned by the city, has been encroached on by these owners, and this is not an improved alley that goes through, but there was a little bit of discussion about whether the alley could be used for some access, but anything related to the site, including the main site or the future development area that relates to access or limiting access or any of those things, those are all fair game as part of the preliminary development plan, so that if what you're suggesting is that instead of having that perhaps the area could be reoriented so there was some sort of road that came through here and then orient the...
Either that or use the access road that's being used for the school apartments as access for those residential areas also.
So if you wanted to have a stipulation that there could be no individual driveway curb cuts on Republic as part of Phase 2, that is within your discretion.
Now, Phase 2, as it stands, it's been at least conceptually presented, and if we approve it, it's going to allow 6 residences there. Before they actually proceed with doing something, does it come back again for detailed review at that time?
As the condition that was imposed by the Planning Commission, which is on page 14 of your report and also in the ordinance, says a final development plan for Phase 2, the future development area, shall be submitted to and approved by the Planning Commission prior to issuance of any building permits. So that was a condition recommended by the Planning Commission and incorporated into the ordinance that's before you. If the City Commission wants to have that opportunity to review that as well, that can be modified so that the City Commission has the final say on that. But as this is structured, the idea is we don't know what's happening here. There's not a specific plan, but the Planning Commission basically forced the plan by saying that we're going to limit this to single-family dwellings only.
Okay, I don't know, really isn't a question, I guess, but it strikes me that most of the feedback we've gotten, including the map here that's related to neighborhood signatures against rezoning, focuses on the area primarily north of the school. There's a little bit south, north of the school, up along Highland and Santa Fe and maybe 4th Street, extending all the way to Crawford. That's quite an extensive neighborhood. And if you draw a circle based on Lowell School, based on the distance from the school to Crawford, you end up with an area that might be considered neighborhood that extends to Broadway. South, it includes Kansas Wesleyan, and to the east, it extends to Roach Street. And while I think that's a bit large, I think it is important to consider that there's a larger neighborhood than just Highland Street. It extends south and east and west some distance. And in answer to your question about rentals, I did look at properties around the area, and it appears to me that somewhere in the order of 40 to 50% of the properties are currently rentals, primarily in single-family homes, but they are rentals. And if you drive the neighborhood, as I have done, you discover that the, what should I say, the housing stock, the appearance of the neighborhood is, there's lots of areas that are very nice, very nicely maintained, but interspersed with that there are homes that I saw that had apparently holes in the roof, or at least parts of the roof that weren't shingled, deteriorating paint, weeds, just all sorts of things. Now they're not overwhelmingly prevalent in the area, but they are there. And I guess my point is that the area does have seeds of blight. I see not doing something with the school as perhaps contributing to that, because if a good use is not found, it sits there not being used, and who knows how well it's going to be taken care of. And I think that is a concern that I have about the future. Sunset Park's within a half mile, admittedly across 9th Street, which is a concern.
Well, I think we all have our, and it's a whole lot of material, but one of the things that we put in your packet was some excerpts from the Parks Master Plan, and the Parks Master Plan referred to this as Park Area Number 9, and it just said that Park Area Number 9, which is described in a map that's in your packets, has 1,717 households, and so it's an area that Park Service Area Number 9 is considered to be serviced by Sunset Park, as I referenced. But there's the Parks Master Plan breaks Salina into, they've identified 15 park service areas and have established boundaries for those. So it's difficult to assign boundaries for what constitutes the neighborhood, but I think some of the perception of neighborhood deals with the property that was within the Lowell Elementary School attendance area. I think that seems to be some correlation between being in the school attendance area and being in the protest petition.
Commissioner Ryan, in response to your question about what the signatories might have known about the petition, it took me a minute because the packet is so big, but it looks like the signature pages lead off with, to the Salina Planning Commission, we oppose rezoning in the Salina Christian Academy, formerly Lowell School, that would allow apartments on the entire 2-acre property.
Repeat that last part, please.
We oppose rezoning the Salina Christian Academy, formerly Lowell School, that would allow apartments on the entire 2-acre property.
Okay. Something that I didn't see in the material were references to the housing study we had done a number of years ago, and looking at that I would just say that it does make a comment that townhouses and apartments are a need, and particular market rate apartments are a need in the community. Also note, comp plan, they did some surveys on needs for playground. That neighborhood indicated that somewhere between 41% and 60% of the respondents said they needed a playground. On the other hand, in response to the question of how well their needs for parks were met, 100% were happy with it. So, again, kind of a mixed message with those things.
Just to ask one thing, Commissioner France, it's difficult to know when those questions were asked, because that park master plan was a long time in development.
Yes,
and it's possible
understand.
that the neighborhood would have had access to those park facilities. I mean, we'll never know.
Possibly.
But yeah.
Yeah. I think that's all I've got for now.
I really don't have any questions. I have comments, but before I make my comments, I'd like to probably hear from the public first. We need to.
I will turn over the podium to someone else who'd like to speak.
This is the portion of the Citizens Forum where individuals can come up and please give us your name and address, and we have a 3-minute clock over here, and we'll be glad to hear from you.
Hello, my name is Dan Peterson, and I live at 948 Highland, about 200 feet from the school. My family and I are opposed to the rezone and believe a more suitable, at least compromise, needs to be worked out, as this does not really match the character of Highland. Community is really a big part of our neighborhood. You'll find neighbors walking the street, talking, kind of circling all of Highland, sitting on their front porches. It's really a front porch neighborhood. It really gives you a sense of what Salina was like, even in the 1920s. And since 1915, there's been a school with a place to play there. When Lowell was closed, the neighborhood was asked what they'd like to see happen with the property. The wish was that it would remain a school with public access. A little history, in 1915, Salina residents passed a bond measure funding the construction of Lowell, so Salina taxpayers paid for the school. Salina Christian Academy was blessed when they were able to purchase the property for just $10,000, as this shows 2.9% of the appraised value, as published in the Salina Journal on March 9, 2004. The article mentions the board decided that many months ago that the purchase price of the buildings would be secondary to finding uses that would fit well with the neighborhoods in which the buildings were located. Park access was provided until approximately 2 years ago, and I have pictures of my kids in the park about that long ago showing it was open. It's really just feels like a disservice to the community that they're able to purchase this so cheaply in good faith, and now they turn around and completely shut us out and not even looking for a compromise. We just feel like they want to maximize every square inch of the property, and it's important to remember in all this that this process is important because it makes sure there's a fit for something, not just throwing whatever needs to go in there. And again, I have 3 kids. The 9th Street issue is a problem trying to get to a park. It's not feasible for kids. It's just hard for people. It doesn't feel like we have a neighborhood park. And really, apartments are inconsistent with surrounding use. In all directions, there's single-family homes. Even all the R2 that they were showing, majority of those around there are single-family homes. So really, we just feel like this is a lose-lose for the neighborhood. If it was single-family homes, there'd be 14 units. Now we're looking at least 21 units, just really adding. And we don't necessarily want more rentals. We want people to be buying houses in the neighborhood, as some have done, even in that 200 zone since that map went out. So we just ask that you either deny the rezone or find a compromise. There's a cover letter for the official protest petition that we have some ideas for compromise, including putting a small park in, moving the parking lot away, because it's really right in the center of everyone on Highland is going to see that. It's just going to be bad. People have said they're going to move away if apartments go in. They're afraid of what's going to happen. So I don't think that really looks good. So really, in conclusion, I'm against the rezone unless a compromise happens. I have provided some safety concerns to staff on a video that I'd like to show if that's okay, in regards to the parking lot. It's a short video. Thank you.
Thank you, Dan. We have a... Okay, do we have anyone else who would like to address the commission?
We don't have any order plan or anything like that, but, so Dan was talking about compromise.
Could we have your name
Oh,
for the...
Joan Ratzlaff.
Thank you.
Salina. Okay, well, just really quickly, I want to say that there's a couple of things that I'm a little unclear on because the the traffic count of 3,100 a day, and I believe the February staff report and the June one said it was 4,000 and some between, for the most recent count. I know the 2018 came from the KDOT's website, but the most recent, the staff report previously said 4,000 and some odd cars between 9th and Santa Fe. Sunset Park is a community park. It is about a half a mile from the school itself, but it's more than a half a mile from the majority of the neighborhood. And the park's master plan, which is, a considerable document, does say a couple of things, and I've made this comment in previous written comments to this matter, that school playgrounds can serve as a neighborhood park. Neighborhood park is someplace that you walk to, and that they should be within a half mile of everyone in town. We don't have that everywhere, but what's good is a plan if we're not following it, and just another one of those things. But I wanted to talk about, the extension of an R2 area, really, on the east side of the future use. It may be zoned R2, but the use is R1, and to me, that has equal weight. Everywhere you see in the ordinance, it talks about use and zoning. The one is not more important than the other. I had issues with some of the findings. I didn't feel that they were accurate, that were presented by the Planning Commission. There's a lot of disagreement among the neighbors about that. The green space increases value. Putting multifamily rentals in that spot would not increase value of homes. And I was talking with a realtor about that today, actually. But Dan presented some of the concerns. There's more, and they've been talked about in February, and we tried in June and in July. And one of them was the hazard associated with the parking lot entrance. Currently, it's a delivery. And we have requested a traffic study for that. I don't think that a decision should be made on that driveway until we have an engineering evaluation, because numerous neighbors have expressed serious safety concerns about adding a driveway to a 30-stall parking lot at that location. Where there's other ideas that have been presented. One of those was in an attachment to that came to you.
30 seconds or so.
That had a park along part of it, or two different ones, with using at 1012 Santa Fe, and Mr. Franz, you may have been referring to that house. 1012 is abandoned. It's going to sheriff's sale unless we can put it in a land bank. It needs to be torn down.
There's several.
And that alley is a divided driveway. It is no longer an alley. It has been vacated, but not the north-south one. So we have an idea of having two entrances off of Beloit and having the parking lot in the middle that serves the development. But I want to say, there are concerns, and we have been working on some solutions. Checking on grants, because that, people kept asking neighbors, well, who's going to buy it? Well, it would make a great park, but we need the money to do that. so we can apply for grants. I've visited with the granting agency, North Central Regional Planning Commission. They advised me about a certain one, and this is all within a week or two. So there is a certain grant that the city could apply for, or the North Central Regional Planning Commission could apply for it. It's not expensive. They could help it buy the land. Numerous
Okay, we need to
numerous grants
wrap up. It'd be fair
would
to
be
everybody.
available to do that. We're saying that we are wanting to provide a solution that provides things that are mentioned in the comprehensive plan and the Parks Master Plan, make the neighbors happy, preserve the value of the neighborhood, and would also work with the developer. So we just need a chance to do that.
Okay, thank you, John.
Thank you.
Hi, I'm Pam Barnes, and I live on 955 Highland. Part of the discussion was the character of our neighborhood, and some things that haven't been mentioned is that it's hundreds of people dress up and come down for Halloween. They come down for the lights and the decorations at Christmas. People come from out of the area to jog on our street. People walk their dogs, their families walk it. It's it's a unique area that I feel that if the apartments change the atmosphere of it, it will be a negative thing for all of Salina, because so many people come down that street that aren't even from our area. Even though there's rentals, it's a safe neighborhood. Nobody feels like there's drug people in these rentals. They're long-term rentals. Most of the people stay there for years renting these places. It's not like an apartment where maybe every 1 or 2 years they move out. I know people will not want to live near them, so they might sell their place, and maybe the neighborhood would get more deteriorated than the couple of houses that are there right now. I moved here over 4 years ago, and I didn't know anything about Salina. I flew here just to see if I wanted to live here, and I just rented a car and drove back and forth all over Salina. And every time I got on Highland, I just knew it was a different neighborhood. And I knew that when I moved here, I would wait for a home that became open, and that's what I did. And I just don't want that to turn into something that I want to leave Salina for if they change everything for us. So thank you.
Thank you, Tammy.
Hello, I'm Jacqueline Cairo. I live at 700 block of Highland. I have lived there, and my family and I and my siblings. I come from a family of 12, so I think I have a good sense of fair play, and I think I recognize unfair play. Like I was starting to say, my family and I have lived in the neighborhood since 1974, both sides of the school. Most of you are probably old enough to know the lyrics to the song by Joni Mitchell. They paved paradise and put up a parking lot. That situation fits perfectly here. The view, the whole atmosphere of that property is bound to be a nice-looking parking lot. The building may be revamped to look beautiful, but it's still going to be apartments. All the calamity and the trappings that go with apartment living will be there. That's a complete change to the neighborhood. Complete change. And that's basically what the neighborhood's trying to do. They're trying to object to that change. They want to say the same. This is a blue-collar paradise for the people that live there. it's not a white collar, Paul. It's not white collar, but it is a blue collar paradise, and it has been that way in the neighborhood for decades. So that's really what the people are after. And I appreciate you bringing, Commissioner Hodges, the conflict of interest issue. I want to reiterate that it's most likely, well, Mr. Olson would have known about this conflict of interest starting in January, when the application was made, all the way through June to where it was brought out by the citizens. And it wasn't me, by the way. I was the messenger on that. It's other neighborhood, Mr. Peterson and Joan Ratzlaff were the ones who really discovered the conflict of interest. And I'd like to mention too that it's very likely, more than, that the applicants and the developer were party to that conflict of interest, or at least knowledge of it. And they seem to, most likely they were complicit with the idea of, I won't use the word, but that. So also, is that my buzzer? Well, that's good enough. I thank you for your time.
Thank you, Jacqueline.
Derek Mullane, 945 Highland. I have lived at that residence for 37 years of my 40. I grew up going to that school, playing at that playground every day, after school, during school, weekends, running around that whole thing. It was just a part of life. All the neighborhood kids gathered there. It was, I mean, it is what the neighborhood was. As the school closed, the academy bought it. My kids were enrolled in the academy, went to school there. It continued as our neighborhood school. When the school closed the playground equipment, yeah, it wasn't a huge deal because the neighborhood had changed age groups, because my generation had moved out. Now the neighborhood has switched, and it is bringing in a lot of younger families that do bring kids to the plate. And the park is definitely needed. Apartments, I don't want to say I'm completely against them. I see that as a good fit for the building, but there is compromise needed. Bringing the park, moving the parking lot to where it's not front and center of what the neighborhood has been for 100 years. That's about all I have to say. I just would like to continue to keep the neighborhood as it has been, and living 6 houses from that intersection, it'll be unsightly to see a parking lot for sure. Regardless of what shrubs or landscape happens, the parking lot's always going to be there. Thank you.
What was your name again? I apologize.
Derek Mullane.
Derek, okay. Thank you, Derek.
Mr. Mayor, Commissioners, thank you for your time this evening. Jeff Mace, Compro Realty, 157 South 7th. Just as a matter of order, is the applicant representative conditioned on the 3 minutes? Or is that for just public comment? Typically, the applicant's heard
Probably. I've allowed it.
I mean, okay.
Yeah.
As a point of clarity, this was done exactly as Mr. Andrew described. I just was curious and started marking up the map, and as it got to look the way it did, I thought this is compelling relative to rentals when apartment rentals is so bad, but the neighborhood clearly has its fair share of density when it comes to rentals. But this only reflects addresses that aren't mailed to that. I don't want to misrepresent anything. I didn't go knock on doors and ask if they owned it, so I don't want that to misrepresent at all. So relative to the conflict of interest, I think it's very important that we bear in mind that Salina Christian Academy is the applicant, not Mr. Richardson. I've been in front of this body and the Planning Commission body a lot, and I generally don't disclose. I disclose as little as we can as a rule, just to not let things get too far out of hand. The only reason that Mr. Richardson is involved at this stage is because we thought, with the concern of staff, but more importantly the concern of the neighbors, that if we could be more transparent and let them know that we have got a very storied developer that's done some fabulous things in our community. I think we can all agree to that. He's taken buildings that have sat empty and have put them back into function, gotten them back on the tax rolls, improved the adjacent property values, and has just been, he's, in my opinion, the most successful developer that the community's seen in years in that regard. We felt like it was a good idea to bring him forward. Didn't think further, but the applicant at Salina Christian Academy has no affiliation with Mr. Olson. The moral of the story here, from my chair, is after the property went under contract with Mr. Richardson, we left it on the market, and we left it, as we always do, potential backup orders, as backup offers, as Mr. Andrews alluded to. So I can assure you that all the calls that we always qualify, because doing what we do, oftentimes we get inquiries about properties that are way far away from what they're actually looking for. So I always ask, what are you looking for? What were your plans for it, etc. The qualified inquiries that we've received to date. Now we took the property off the market the week before the July 7th Planning Commission meeting, but prior to that, everyone that called were multifamily developers. That was, that were really inquiring. We had people that were just interested in what the price was and things like that. But as we got down and drilled into the inquiries, they were primarily multifamily developers. Many of them from out of town that target schools to go in and do this very thing because you can get the historic elements involved. So as you think about this application and what you're doing to the underlying real estate, I invite you to think about it as Salina Christian Academy as the applicant, because in order for us to put that building back into production, we really believe that multifamily is the way to handle that building to get it back functioning. I'm going to leave you with one quick thing as I see the clock. I brought this up at the last commission meeting, and I think it's relative to your considerations as we talk about compromise and we talk about we need a park in Dr. Davis, pardon me, Dr. Davis and Mary Davis. I don't know which one's appropriate, so pardon me. But I read this to the Planning Commission because I think it's germane to your consideration. It's regulatory taking. In the United States constitutional law, regulatory taking is a situation in which a government regulation limits the uses of private property, that's exactly what we're talking about here, to such a degree that the regulation effectively deprives the property owners of economically reasonable use or value of the property, to such an extent that it deprives them of utility or value of that property, even though the regulation does not formally divest them of title to it. So as we talk about, no, I'm not going to rezone it because I want it to be a park. When we first came in front of the Planning Commission, the park idea was brought out. Mr. Andrews sitting right there. I looked at Mr. Andrews and I said, are you signing the contract or is Craig going to sign this contract? Because it sounds like the city just bought themselves a piece of property to put a park in. But it is, like it or not, private property. And we can't go on and we can't let this idea that, well, I won't rezone it because I want it to ultimately be a park and the Salina Christian Academy has to sit there for another 2 years while that building continues to deteriorate. So I do think that regulatory taking is very close to some of these questions, not at all the action that you may or may not take, but some of the things that are being asked, I think by constitutional law could be deemed illegal. So as the applicant, I'm happy to answer any questions you may have. I know you've had a long meeting.
I just had one question that maybe for you. What is the condition of that building currently?
I'm going to let Mr. Reynolds come up as a public citizen and answer that question because he's more familiar. I mean, I know, but I'm going to let Mr. Reynolds, who's the board of Salina Christian Academy, speak to that if that's okay. Because he's more qualified than I am to answer your question.
Okay.
Any other questions of me, though?
Well, I don't know if this is for you either. Is there any thought been given to what sort of apartments might go in there? I referenced market rate apartments.
Market rate apartments.
Okay.
Historic tax credits are going to be used, but market rate apartments.
Okay.
That's a question I have.
Absolutely. All right, thank you very much again for your time.
Thank you.
Could I just ask for a clarification from the city attorney? Just since I don't think any of the five of us are attorneys, with reference to the term regulatory taking, does that apply if the zoning of the building is the same now as it was before it was bought the first time and has remained the same? I mean, as opposed to it being bought in one circumstance and zoning having been changed, since the building was bought. Yeah.
I'm sorry. The reason I'm looking at my iPad, we anticipated that question, and I do have a summary if you or the commission wishes to hear. The case that dictates the factors that go into that regulatory taking analysis is the Penn Central case, and they're referred to as the Penn Central factors. And I am happy to go into that if that's something
I would, because it really reflects on the first question I asked, or the second question, to what extent is the city obligated to help someone sell a property that they can't move because of the way it's zoned?
Well, if it's yours and the commission's wish, I'd be happy to
I'm only one of five.
read this.
Commissioner Davis wants,
I'm no
that's fine.
constitutional scholar.
This is a memorandum, actually, well, an email. It's not terribly long, but prepared by Aaron Martin and sent to me in anticipation of the discussion. The issue of whether a taking has occurred by virtue of any decision to deny the Lowell rezoning would be addressed under the Penn Central factors. The factors are: 1, the economic impact of the regulation on the claimant. The claimant in this case would presumably be the current owner. Number 2, the extent by which the regulation has interfered with distinct investment-backed expectations. And 3, the character of the governmental action. In the context of a takings claim premised upon denial of a zoning request, the most relevant factor is the second factor, involving the landowner's, quote, investment-backed expectations. As a preliminary matter, in the Palazzolo versus Rhode Island case, the United States Supreme Court explained that there is no per se rule that prohibits a Penn Central takings claim by the mere fact that title was acquired after the effective date of the state-imposed restriction. The state-imposed restriction would be the original zoning. The court reasoned that otherwise the post-enactment transfer of title would absolve the state of its obligation to defend any action restricting land use, no matter how extreme or unreasonable. However, when courts review a takings claim premised upon the government's denial of a requested rezoning, it is generally held that the, quote, investment-backed expectations factor of the Penn Central test is not satisfied, and this weighs heavily in support of the government, absent unique facts that support the landowner's belief that he or she is entitled to rezoning. Another case, Grand Sakwa of Northfield versus, it doesn't matter, I suppose. It is a Michigan appeals court case. The plaintiff unsuccessfully asserted a takings claim against the city based upon the city's denial of a rezoning. In determining that there was no legitimate investment-backed expectation because the property owner acquired the land knowing that it would have to be rezoned to accomplish its desired use. The court reasoned that a claimant who purchases land that is subject to zoning limitations with the intent to seek a modification of those limitations accepts the business risk that the limitations will remain in place or be only partially modified. As Justice O'Connor noted in her concurrence in that Palazzo case I referred to earlier, The regulatory regimen in place at the time the claimant acquires the property at issue helps to shape the reasonableness of those expectations. Notice of the regulation cannot absolutely bar a taking claim, but it should be taken into account. In short, there is no per se rule that prohibits an owner from asserting a takings claim based on the denial of a rezoning request. But the investment-backed expectations factor of the Penn Central balancing test almost always results in a denial of the takings claim on the basis that there were no distinct investment-backed expectations of a particular alternative use, since the owner should have known that any alternative use is contingent upon a rezoning being approved. The point being that any court would take those factors into consideration.
If I may, I think one of those factors was the character of the government's action, and I believe that Mr. Mays was making a distinction that if your decision is for the purpose of turning it into a park, now your regulatory decision has been implicated by your intent to use that property for city purposes. So I think you need to make a independent, distinct decision about the merits of the rezoning. Use as a park, or your intention to use that as a park, it could be a legal concern.
Yes, that's certainly an accurate statement as well. I think you have a balancing here that I think the point is it is more difficult for a claimant to assert a takings claim when they are basing that claim on a denial of a rezoning in order to fulfill whatever economic interest they might be in pursuit of. By the same token, Mr. Scragg's point is correct. Certainly, the other side of that coin is you would not want to deny a rezoning if somehow you were motivated by the point that I might best leave you to articulate it.
Motivated to repurpose it as a park.
Right, okay. But failure to rezone property which has been used for its original purpose for a very long time, without any zoning changes during that period of time, would not necessarily be considered a regulatory taking.
Well, and I'm sorry, we're in that area where those factors are all three going to be at play. That makes for a little harder prediction in any particular cases, but so it's hard to speak in absolute terms. Mm-hmm. But those are the factors that would be under consideration if there were a claim of a takings claim asserted.
Mm-hmm. Thank you.
Mr. Reynolds, I take it you're Mr. Reynolds. You started this direction when I was asking about the condition of the
It's
building.
an important question. Thank you very much, everybody.
Go ahead and state your name and
I'm
address.
Jim Reynolds. My address is 5261 West Stimmel Road, Salina. And so I've been with Salina Christian Academy since its founding. I was one of the original founders of the school. We founded the school in 2003 and had the school year 2003-2004 at a different location than Lowell Elementary School. All that time we were negotiating with 305 for one of the school buildings that they had for sale. Our original offer was for Hawthorne, and they thought that Lowell would be a better fit for what we had going on, and it turned out to be they were right. I want to give you a little history about just going into this place that had been vacant for 2 years and what that was like. In the 2 years after they had quit using it as a public school, the roof had given out. It gave up the ghost, and it was leaking throughout the entire building. The day that we went in and toured the school, it was raining. There was water running down the insides of most of the walls. When we went to turn on the lights in the building, there was a massive electrical arc. We didn't realize it at the time, but the water had gotten into the conduits for all of the electricity in the south wing of the school, and it blew it all out instantly. So when we got into the school, first order of repair was a new roof, plus a whole new electrical system in the south wing. And then all new carpeting throughout the building, mold remediation, a lot of plumbing repairs, tons of broken glass repair from bullet holes or BB gun holes and rocks and bottles, a plethora of dead birds, bats, and live bats, and a number of very large rodents. So buildings fall into very bad disrepair very quickly when they're unoccupied, and this one had. We put together a crew of people and put my business into it as well, volunteering its time to restore this building through the summer of 2004 so we could have school there in the fall of 2004. It was a massive undertaking. It was stated that we bought the building for $10,000, which we did. We spent $250,000 repairing it that summer. Through the course of the next few years, we put another $100,000 into repairs in the facility just to keep it upgraded and make necessary repairs to it. It served us well. We love the neighborhood. It was a great fit for us. We had neighbors that were on adjacent properties that took very good care to watch out for our school and let us know when things were going on around there. The first few years that we were in operation, we had the playground open for public use. We wanted to be a good neighbor. But we quickly found out that not everybody attends their children when they go to the playground. And so with an open fire escape on the back side of the building with a couple of roofs adjacent to it, it became pretty obvious that we needed to stop that practice because it was just simply too dangerous to allow kids in there when they were unsupervised. Over the years, we've had a lot of trash thrown over the fences. We've had other broken windows. Last November, I got a call from one of the neighbors. Told me that he had observed a couple of homeless-looking people in there the night before. It looked like they spent the night in the backyard behind the building. So there's just a lot of things that happen when a building is unattended. And for this building to remain unattended, it's in very good condition right now. In need of major upgrading, though, a lot of major upgrading. And so there's going to be a lot of money that's going to have to be spent on this thing. A lot of tuck pointing to the outside, a lot of entrance replacements, and that sort of thing that are beginning to deteriorate pretty badly. It's going to take a lot of money to keep this thing alive, and I think Mr. Richardson will do a great job with that, based on what I've seen him do around Salina. And we're grateful for the offer that he's made to the school, which will cover our mortgage only. The money that's left over, which is quickly disappearing due to the months that we're waiting to close this deal, is going to be set aside as a scholarship for another Christian school to help kids be able to attend that. So I hope we can come to a really good resolution for the use of this building. I think it will be a benefit to the neighborhood, and I know it'll be a benefit to keeping this building in very good shape for a long time into the future. So thank you very much for all of your time and your efforts in this.
Thank you, Mr. Reynolds. Okay, do we have anyone else from the public that would like to speak? Okay. If you've already been up once, sorry, it's not fair. We'll just keep that merry-go-round. I guess I don't really have a lot of questions. I do have a couple comments. I've been making notes here, and I was glad to have this in here that kind of talked a little bit, that showed the number of rental properties. I know we've talked a lot about the future development portion of this. I think the PDD protects the city. I'm guessing if you ask the developer, he probably doesn't like the PDD because we can hold his feet to the fire as we look at developing that portion. I understand that the unknown is somewhat scary to the neighbors, and I understand your concerns. But I've looked at prior projects. I look at the Roosevelt Lincoln School and Hawthorne, and those I think are good examples of how properties that were deteriorating and or would have even gotten worse have been made an asset to the community. I know that the St. John's Hospital was brought up, and I don't know, at one point I think we had a picture of this, and this is kind of what I'm concerned about, and I would be real concerned about if I was in the neighborhood. This building, I believe, was a city commission back in 2014. Does that sound about right?
That's right.
Denied this facility being torn down, and since then it's under ownership of an LLC, and basically it just continues to deteriorate. Water's running inside, windows are being broke. That's what I do not want to see happen to Lowell School. I think that I have driven that neighborhood since this has come up, I bet 20 times. I noticed that there are some duplexes on Beloit there. Because of the age of the neighborhood, it's typical that there's the very mixed bag of properties, as Commissioner Fran said. There's good and there's bad. I really think this building being refurbished can help the neighborhood. I think that it can be a good neighbor. I just don't want to see this building, and I think Mr. Reynolds said it, an empty building deteriorates fairly quickly. And that is the Highland, Beloit, Republic area is a nice area, and we want to keep it that way. I was glad to hear that these are market rate apartments, so we're not having subsidized property there, which I think helped me a little bit on this. So buildings like this are not always easy to find uses for. I know those were kind of my comments. So I'll let any of the other commissioners make comments and move on.
Okay, well, I keep hearing references to people who are renting. But in Salina, a lot of the renters are family members of the owners of the house. We all probably have had kids who needed help, or they live in a house, an older relative has died or whatever. We got medical students here, medical residents who are renting houses, grad students, college student, new families starting out, so a lot of times it's the first place they live before they move and buy their house. So, I'm more concerned about the condition the property is being kept in rather than whether that person owns it. It's great, homeowners tend to take better care of the property because it's their property, but just being a renter we shouldn't give the impression we're looking down on people who are renting houses. I agree, you've got to do something with the building. I mean, it's either tear it down, build new houses, or use it for what it can be used for. Some old buildings are better off torn down, and I love old buildings, I mean, very much so. If it can be repurposed, that's great. I think if it's in a planned development district, there can be pressure put to adjust the landscaping and the borders and the lighting so that it fits in with a residential neighborhood. I think the Phase 2, I personally prefer the PDD R1. I mean, if it's going to be single-family homes, then just say that from the beginning. It's single-family homes, and don't leave it to question in the future. The property, I mean, the traffic needs to be resolved, because that street, and I'm used to driving in East Coast streets, which are narrow, cars double parked, people going the wrong way. That stretch of Republic is a rough street, is a rough block to navigate. And I would imagine with a few extra curb cuts and a lot of traffic, it won't be long before you have your increased share of accidents there. And I'm trying to, I'm more concerned about the Phase 2, and like I said, I like the PDD part, because that's, I think, is the chance for the neighbors to influence what the building looks like. Something's going to have to happen to it. If there's a neighbor who wants to pay SCA more for it than what they might get from a proposed buyer, then somebody could buy it, I guess, and put a park in, but you still have liability issues. But I think just as a city, if you look at that map of neighborhood parks, once you get south of Crawford Street, and I'm assuming there's a time in our city's development, neighborhood parks just disappeared from the scene of the earth, face of the earth. And they're great little places for neighborhood value. But there are really none in the southern half of the city. But that's not what we're here to discuss tonight. But I would, I think we're going to have to come up with a compromise, and for me, the compromise is in the phase two area. I'm done.
And I think there are some areas for compromise, and forgive me, because you're going to get my whole stream of consciousness that I've been writing things down, so tune out if you need to. But I was, like the rest of my fellow commissioners, I was driving around the community, looking at Franklin, looking at Bartlett, Hageman, Roosevelt, Lincoln, because I've had a really hard time with this decision, and I don't think it's because I actually had an accident at that intersection where I took off a person's door of their car when they opened it. And I don't think it's sentimental reasons, because that is my neighborhood grade school. Ever since that school closed, I've known that there's going to be another chapter in that school's life. But the things that I saw about Franklin and Bartlett and Hageman and Hawthorne and Roosevelt Lincoln they had some commonalities, and those were they either abutted a commercial area, or they were located on a major arterial street. And unfortunately, or fortunately, Lowell is really kind of marooned in a sea of R1 development. Lowell is not on Santa Fe. It's not on 9th Street. It's really in its own little area, which I think makes it very difficult to evaluate. And I think that justifies the extra layer of scrutiny, and I hope the extra restrictions that we're entertaining right now. I really appreciate all the work that Mr. Richardson has done in the community to revitalize older buildings, because I think that's a niche that was totally unexplored, and I think he's done a good job of recognizing the potential, and I've loved seeing the apartments on Iron transform in particular. However, I think it also merits looking in terms of the development that's occurring just to the south of Market Aid, and something that I would hope that maybe doing some sort of a PDD here will help us end up with a product, if this is the route that we go, that's more compatible with the size, the height of the surrounding neighborhood. I realize that, I just think that I'm not saying that, there's a particular architectural genre or anything like that to dictate, but I think that it does merit, as some of the materials we have received, talking about height, talking about spacing, talking about, frankly, where to put the parking lot. I don't think that and like I said, I'm not a constitutional scholar, but, asking for different options to put so that the parking lot isn't the first thing that you see, that's something I'd love to see. I also agree with Commissioner Davis that, to me, it seems much more forthright to be declaring this an R1 PDD as opposed to an R2 to PDD. And I think also we need, as Commissioner France mentioned, to have some conversation about limiting of curb cuts, because if we're talking about single-family houses on that stretch of Republic, that's just going to be a pretty heavy burden. And I guess I would just look to staff, I guess, to see if we have done any kind of an engineering evaluation of that intersection.
Mr. Mayor, in fact, maybe just throw another question in since Mr. Andrews is coming up. We've been talking about 15 apartments, and it's a question I should have asked, but is there any estimate of the number of people? It's different to have 15 three-bedroom apartments as opposed to 15 one-bedroom apartments. And I don't remember seeing in any of this if there was an estimate of the number of people that represents.
I can't speak to what the plan is in terms of the breakdown of one-bedroom, two-bedroom, or even three-bedroom apartments. That would be something that the applicant would have to address. I was just going to address the only thing we've done from a traffic standpoint is we've conferred with KDOT on traffic counts. Mr. Hers and I went out and measured every pertinent dimension in the intersection and all the street widths and the distances and all that, so we would have factual information as to those distances and separations. And we have the traffic counts, and we sought accident reports from the police department. But in terms of an engineering study, there is part of the reason that Republic is narrower between Santa Fe and Highland is there's a when you have properties that are in different subdivisions and you don't take great care when you're piecing subdivisions together, sometimes you get streets that don't line up. In the case of Republic, the strip between Santa Fe and Highland has a much narrower right-of-way than a typical street, and because the right-of-way is narrower, the street is narrower. So it's a product of that. So there's not a great deal that can be done to change the geometrics of the width of Republic on that stretch. So all we've tried to do is and in terms of proximity to intersections or anything similar, is we had a similar situation that we looked at in the case of the Donna Veneer Children's Center, where Oakdale has an offset intersection at Ash Street, and there is a driveway on the Donna Veneer's Children's Center that's in fairly close proximity to the Oakdale Avenue intersection, and we agreed to monitor that, and we have found that it has not created hazards that have resulted in any undue number of accidents or conflicts there. But that's in terms of where else do we have streets that intersect that don't line up with each other. Oakdale does not line up north and south at Ash Street, and we do have a driveway for the Donna Veneer Children's Center. It's actually closer than what any driveway here would be to Highland. But in terms of, I'm not sure what you mean by engineering steady, but we went out and made sure that we knew all the pertinent dimensions and separations and confirmed all those so that you would have that for your report.
And I appreciate that. I appreciate that level of detail and accuracy, so thank you for that. I mean, I think what I'm also talking about is, and obviously this has been in the works for months and months and months, but, you know, if there's any consideration of whether that could be, you know, moved to the east, as I mentioned before, an alternative location for the parking lot that would provide more screening. But in terms of moving the driveway somewhat further to the east.
Well, in terms of, as we indicated in our report, although they're linked, because in any action that might approve a change of zoning to planned development district, the preliminary development plan is part and parcel of that action. So anything that relates to the site plan, such as the action that the Planning Commission took to recommend that there be 2 connection points, is fair game. The only thing I would point out is that if you push the parking lot too far to the east, then you don't have a phase 2. You start encroaching into the phase 2. So if you could go to the site development plan, Dustin. In terms of shifting driveways, is this driveway is going to have to be reworked? Could it be moved over here? Absolutely. It would line up with something that was here. Could this be eliminated here and make this more linear? Absolutely. All those things are within your discretion. It's just a matter of conditioning or making those revisions. This is conceptual, and so just because there's a curb cut there doesn't mean it can't be here. And as Mr. Franz mentioned, if you don't want to have a curb cut on Republic at all, you can specify that the access is to Beloit. If you don't want to have any curb cuts for these and that they have to have alternative access, you can make that part of any action. So anything when it comes to regulating access points is within your jurisdiction as a governing body.
I believe I have a document that would help to answer that question. It's Kansas Traffic Engineering Assistance Program through KDOT.
You can, once you give
Could
that to
I
staff.
give this to you?
You can give it to staff. Comments down, Commissioner Ryan or Franz?
None. It's 10:15 and it's time to act. Sorry.
Well, I don't have any particular comments. I'm just curious, Al, if there's going to be a compromise, how we reach that and what that might be. I actually like the idea of shifting the access to the parking lot a little bit, but I don't know how realistic that is, if we can make that requirement now, or if we simply say it comes at the next step of the process.
I would have to look at staff for an answer on that. Here comes Mr. Andrews.
I guess my comment would be that if you, we've talked about your options in terms of major or minor revisions to the site plan. If you, one of your options is to postpone consideration of the application to allow additional information to be provided by staff or the applicant. If one of the things, if you had if there was a consensus to certain things that you wanted to see different or depicted more clearly on a site plan for your consideration, and you could articulate those, one of the things you could do would be to postpone consideration to allow those things to be incorporated into a drawing that you could then evaluate. But to do that, you would have to have a general consensus or some sort of action to allow time for the site plan portion of this to be modified to reflect those things that you'd like to see differently. That's all I can suggest in terms of the site plan. But in terms of, you have all kinds of discretion to direct that revisions be made to the site plan, but you're going to have to do that in some consensus fashion as a body to allow those things to be incorporated if you want to see what those look like before you took any action on the zoning as well as the site plan.
Yes, part of my comment would be is it appears we've already, we've added the second exit down at Beloit Street. To me, I'm guessing the residents make that call depending on which one's the safer, which one they're more comfortable using as far as an exit, so I'm not...
Well, I mean, just from a practical standpoint, this is an existing curb cut. If you had a curb cut down here, you can't line this curb cut up down here because you'd be going through the building. So that would, if the parking lot is going to be lined up east of the building, then it's very likely that this is going to be shifted to the east. But you can't shift it so far to the east that it starts encroaching into here.
Exactly, it's got to be part of this, yeah.
Or even if it's, one way, turning into a narrow parking lot is easier than coming out of one. But, those are decisions that, I don't know if we need to go into that detail ourselves, but certainly to come back with other ideas. If we wish to make the future development a PDD R1, is that considered option 2 here, disagreeing with the recommendation, sending it back to them with that suggestion?
I don't think you'd be disagreeing with the Planning Commission because you are agreeing with them that it should be limited to single family, and it's just a matter of drafting that whether the underlying zoning is PDD R1 for the future development area. That's just a simpler matter of drafting in terms of modifying the ordinance to reflect that. They just didn't make that specific of a recommendation, but they did recommend, and what's before you is saying single family only in the phase 2 future development area.
If that's the only change, I think we might be able to prepare that between first and second reading. If you're going further than that, then I agree with Mr. Andrew. We're going to need more clarity from you. And while I understand the desire to look at a plan, we're going to be caught in this catch-22 of a repeated cycle of proposing a plan and then discussing. The more clarity that you can provide, the more it's going to expedite the decision, and the more it's going to assist the applicant to provide the plan that you ultimately are looking for.
If I might pursue a little bit of detail, what we see up there is the location of that parking lot. It says not to scale, but is the location correct, or is it going to shift further west, or I mean, how, because that does not look like it lines up with Highland coming in from the north. It may catch part of it.
Okay, we would probably have to go back and forth from the aerial photo to this, Mr. Hers, but this is the existing curb cut.
Okay.
If that curb cut is utilized, it comes down and catches the corner of this building.
Okay, but where is the west edge of the parking lot is conceptualized? Is it lined up with that crosswalk? Is it further west?
Conceptually, the boundary is here. And so it's shown as the edge of this. In order to have a straight pass-through between Republic and Beloit,
okay,
this is probably going to have to be shifted to here, and then we're going to be lining up east, because you have to remember, to make this work and to get 30 stalls, you're going to have to put a aisle down here and probably have stalls on either side, and so that's going to put the curb cut over here.
Okay. Maybe I'm too deep in the weeds at this point, but that location I find a lot more acceptable than one that was further west.
And in that scenario, is that a one-way drive through the parking lot with the stalls on both sides?
I believe it would be designed and intended to be two-way, to allow for both entrance and exit. That's what our code would require, unless if they choose to do angled parking, then if they did angled parking, then conceivably you could have an entrance here and an exit on Beloit, but I think the goal or the desire of the Planning Commission was to have 2 entrances, exits that could be used for either turning movement, and it was their belief that over time, if Republic was too difficult to navigate, that most residents would simply choose to use Beloit. But I think the assumption should be that it's a 2-way driving aisle.
Okay. And this parking lot then would be oriented north-south. And the reason I ask, in the picture of the worst-case scenario for the appearance of the parking lot, it was oriented east-west in that picture. But this parking lot would be
North-south?
north-south.
Well,
Dean, can I borrow your laser pointer for a second? And in answer to Commissioner Franz's question, the western boundary of the proposed parking lot lines up with this this drive-in, the edge of that drive entrance.
okay.
So Dustin, if you could scroll down a little bit. Now I've lost the drive entrance.
So you will not see the parking lot from Highland.
Coming down Highland until you get pretty close to it. Yeah.
And it would be how wide on that same drawing?
Yeah, well, I don't know.
As far as east-west dimension.
I guess we could look at the material.
Speak to the fact that if you have 90-degree parking and you have to have a 24-foot driving aisle, 19-foot stalls and 19-foot stalls, so that it's 62 feet of paving width to have a double row of parking. So if you were doing that, you would have to put the parking beside the east side of the building, you would have to have 62-foot width of paving to have 2 rows of stalls on either side of a 24-foot driving aisle.
So almost twice as wide as Highland is coming down.
Yes.
Okay.
You'd have 62 feet of paving.
So even though it's oriented north-south, it still takes up a lot of space east-west.
The parking lot would most likely have 62 feet east to west that it would occupy to have the double row of parking.
And, like a little nuance, could it be specified that the first stall doesn't start until so many feet in, or there may already be a rule, I don't know.
There is a rule to that effect, but the minimum buffer is 5 feet. So you have to have a landscape buffer at least 5 feet in width between the property line and where the paving starts. And that landscape buffer would consist of low-growing shrubs and trees.
And that could be increased, but the minimum is 5.
The minimum is 5, but it could be increased. But if you're looking at 30 parking spaces, you're depending on how or where you locate that, you're looking at getting 15 stalls on either side of a driving aisle. So.
Okay. I'd like a 10-foot buffer. I mean, as far as protecting the view from Republic or from the north. I don't know how many feet down the block is, but it looks like you could get 15 on either side.
If it's helpful, I think Mr. Richardson's willing to speak to some of the parking questions, or at least speak to the topic, maybe.
Somebody, please. Beat this to death. Let's see if we can.
Brian Richardson, 361 Northmore. I think the plan coming out of Planning Commission, we made the changes so that we could actually get it on a 44-foot wide. So running, as you guys are talking, moving that curb cut on the north a little bit farther east so we can get a straight shot over to Beloit. We would be at 20 foot for parking. 24-foot drive-through, which gives us the 44. The lots are 50 feet wide, so we'll have a buffer to the east. That will allow us to basically not then encroach on that sand.
I'm getting dizzy.
So we would end up being able to keep parking clear back here, because we can get a row of parking on this, and then we only need single parking to go the rest of the direction to get the 30 cars that we need. And then we're going to be a little wider in the middle, which will allow the trash truck and services to come in here and get that so it's hidden behind the building, that it's not sticking out in the front. So we end up with one row of parking all the way through, another row of parking here, but we're back at this instead of building clear out to here.
That's very helpful for me. Thank you.
So that would be the current plan now, and that would not require us to make any recommendations?
Planning Commission that we agreed to do.
Okay. Thank you. So then, my major request would be that we specify the Phase 2 as PDD R1. So we don't have to visit this again 5 years from now.
We need to take care of the future land use designation
So we gotta
first.
do that first, yeah. All right, well, I'll get that part started. Mayor Hoppick, I move that we concur with the recommendation of the Planning Commission. There's probably a better official reading for this. Bear with me. Yeah, I guess there isn't. So we can concur with the recommendation of the Planning Commission to approve ordinance number 20-11027, amending the future land use designation of this 2.04 acre tract of land from public, semi-public to urban residential on first reading.
Second.
We have a motion and a second to concur with the recommendation of the Planning Commission approving ordinance number 20-11027, amending the future land use designation to public, semi-public to urban residential. All those in favor?
Aye.
Opposed? That passes 5-0 on first reading.
Commissioners, I don't want to get ahead of you. I don't know if there's more conditions. You certainly need to articulate those, but as a possibility, I think you could approve the ordinance on first reading, provided that the legal description is amended such that the eastern 6 lots are described separately to be R1 PDD, and adding a condition that parking shall be installed in the configuration in the attached exhibit, which would have to be prepared and attached by second reading. But I don't know if those are all your concerns, but the two that I've heard, that might be a way to address them between first and second reading.
Would you repeat those?
Instruct staff to prepare an amended description separating out the east half or east 6 lots to be designated as R1 PDD, and then adding a condition that the parking shall be configured as depicted on the attached exhibit, knowing the exhibit will have to be prepared and attached by second reading.
I just had one question. It was related to a suggestion that you had earlier in terms of limiting the driveway access for, in the future development, in terms of adding more driveway egress onto.
That's why you do a PDD, because that has to be addressed.
My
in the
concern there
future.
is if it is R1 and there's single-family houses along,
Right.
then we've got 3 more driveways we're putting out on Beloit, and I'm not convinced that R1 PDD is what we should do right now. I actually like the concept I saw in our packet, and I have no idea if it's possible, of having 4 duplexes with interior access through the same access as we get here. Now, I don't know that works at all or not, but it was a nice drawing, you know.
Well, and the PDD, it still has to come before the planning commission
Yeah.
and the
Whether
city
it's-
commission. So whether it's PDD R2 or R1, R2 gives you more flexibility.
I'm not sure if I'm on board with that. I'm not sure what we gain by it, I guess.
Are duplexes considered single-family?
They are not. They would be multifamily if that was the approach taken. But the condition right now is that they are, with the PDD as it is now, is that there would be up to 6 single-family homes. So that would need to be changed at some point in the future if they wanted to do that. I guess I just don't know what we gain by going to an R1 as opposed to an R2.
Would there be
When a
differences?
PDD says, well, the PDD specification says single-family residences already.
Well, then, what's the functional difference between those two?
The main difference is, I explained and Commissioner Hodges observed, is that it's more, if someone was looking at a zoning map, showing that on a map as PDD R1 would be more, it would convey something clearer to people than if you saw PDD R2 would imply 1 or 2 family dwellings, then you'd have to dig deeper to see the actual ordinance that's in fact limited to 1 dwelling. So the advantage of making the eastern portion Planned Development District R1 is then it's crystal clear to everyone that it's limited to single family. It wasn't laziness that compelled it to be PDD-R2 all over. It was just the fact that the Planning Commission was wrestling about whether to allow duplexes in Phase 2 or not, and R2 was needed for duplexes, but they came down to limiting it to single-family dwellings. But as Mr. Franz indicated, it's not necessary, but what the PDD-R1 does is it conveys to the public or anybody looking at a map that they know, if I own a lot on Santa Fe and I'm looking at a zoning map, I know what R1 means.
And that doesn't preclude 10 years from now someone coming requesting it be changed?
By the advantage, as Commissioner Hodges pointed out, is that someone who's looking and they look at a zoning map and it says PDD-R1, they know exactly what that means. If it says PDD-R2, it's subject to interpretation.
Right, that's what I thought you
So
had
it's a
said,
matter of
but yeah.
clarity.
It's just a matter of clarity.
Okay.
And I
And
think
should someone in the future want to go in and, say, change it from single-family to duplexes, they would then go through the process of amending the PDD and amending the zoning to R2 PDD with a new set of conditions.
Yes, and we'd be in a setting just like we are this evening.
Well, and in terms of precluding, without further detail, it's going to require what you just described in terms of coming back with an amendment regardless.
Okay.
Because there'll need to be a
Then I
detailed
retract my
plan.
objection to an R1 PDD. It's, you know.
And let me just say this in support of that. I mean, I think that neighbors are very justified to be skeptical and not supportive of this development. And I think our main responsibility is to see that when we are promoting infill, that it's not done to the detriment of those who are there already. And I'm not wild about this, but I can come to grips better with it if we at least have that R1 PDD setting up at least what our expectations are in the moment right now. Whether that changes, with the understanding that it can change in the future.
So Commissioner Davis, would you like to change your motion?
Well, I
There hasn't
haven't
been a
done one
motion.
for
There's not a
the,
motion made yet.
Oh, there's not a motion
No.
on it? Okay.
I'll make one, but yeah, I mean.
I thought he'd already stepped forward with that.
Well, I was writing stuff down, but I'll throw it out. Feel free to change it. Mr. Mayor, I move that we concur with the findings and recommendations of the Planning Commission Ordinance Number 20-11030, rezoning this 2.04 acre tract of land to PDD 2 and instruct staff to amend the description of the eastern portion of this property to R1 PDD and adding parking,
Exhibit.
Updated site
adding
plan.
an updated parking exhibit to the, as an attached exhibit when this returns for second reading. And if there was a request for a 10-foot buffer, would that be added in here now? Or
If that's your desire, yes, I'd suggest you
if
do it
not,
now.
feel free to amend it. And with the 10-foot buffer from Republic Street south to the beginning of the parking stalls.
Second.
Okay, you're gonna have to tell me, where's the buffer at?
Between
Explain the
the
buffer.
sidewalk on Republic and the first parking stall. Right there, yeah.
Just saying along the curb line of the street,
Correct.
yeah. So if there's maybe a little screening or something that could be done there.
Okay, let's see if I can get this. We have a motion and a second to concur with the findings and recommendation of the Planning Commission, ordinance number 20113030, rezoning the 2.04 acre tract of land to PDD R2 on the proposed first phase and PDD R1 on the future development, being the east portion of the plat, along with an updated parking exhibit to be attached and a 10-foot buffer along the parking lot facing Republic Avenue. Does that get it?
And just to clarify, you would be approving on first reading, approving this ordinance on first reading.
Right, on first reading. Okay, all those in favor?
Aye.
Aye. Opposed? That passes 5-0. Okay, I think we still have a executive session.
We do have one other short other business.
Other business, okay?
Yeah, I would like to instruct staff to repeat the conflict of interest education for the Planning Commission, not waiting until September, primarily because they're going to hear more cases between now and September. Analogous to our having to go to a Coracoma meeting in between the time that we would normally have done it.
Yeah, I like that idea.
We change out a big portion of that in August, so I'm not sure we can get that done before.
Yeah, we
lose 4 commissioners.
Okay,
that
of
come
any
out in
commissioner
September.
who is continuing on. I mean, we're talking an hour, it won't hurt them to sit through an hour, even if they're leaving, but certainly for the commissioners whose terms are not expiring in next month.
So I think as Dean mentioned, Lauren Driscoll, Director of Community and Development Services, in September, we hold this training. We cannot mandate a commissioner to show up to anything. I mean, we tell them in advance, we encourage it. I can, between now and then, make sure that we talk about the ethics policy just under maybe other business, make sure they have a copy of it. We always provide a copy in September when we do that training.
And I understand the frustrating place you're in because you can't mandate that, but we can, can't we? As a
can.
condition of service on the board? I mean, because Mr. Olson obviously, for whatever reason, didn't attend last September, so therefore he's going a whole additional calendar year not having the materials he needs to do his job successfully and effectively. So, I mean, on certain boards, I think it's, I'd be interested in talking about making it a requirement to get your board orientation that includes going over our ethics policy before you sit up here and start making decisions about other people's lives,
Right.
especially Planning Commission.
And
Well,
we
and I
could
could
narrow
double-
it down to any commissioner who was not present for the instruction last September.
Well, I could double check too. So roughly quarterly, for commissioners that come in off schedule, we also provide like a sandwich lunch and have them come in, introduce them to their appropriate staff members, let them know about our protocols about how to get your packets. And then we do a slide that's probably like 20 slides long. And, there's a couple of them in there that said, be aware that parliamentary procedure is a key to being a part of this. We have ethics, those types of things. So at least they're even touched on in that brief component. And we do provide, again, a copy of the ethics materials then too. And I could check to see if he sat in one of those post September. Sometimes if they've missed something, they can. But I
have no problem leaving it up to the two of you to decide how you do it, but just make sure it's done before he sits in front of another case. Because he obviously didn't understand it the first time.
So, Mr. Manager, do we have to have formal recommendation from the mayor that's...
Yeah, I think
Since they're his
we need a
appointees.
motion and a vote to make sure it's representative of the governing body's direction. One practical thing, the Planning Commission is meeting once a month, and so they'll meet, which day in August? August 4th. So they'll meet August 4th, and then they'll meet again, their next meeting will be in September, and so we will have to conduct the training in September for the new commissioners that will need to be appointed. So we'll be conducting the training August and then again in September.
But that would be after the September, forget which day you said, but
So
after.
their September meeting will be their annual business meeting.
So that would be
And
August and
if we conduct it
September.
in August, we don't catch the new appointees.
Right,
we'll be
so the new
conducting the same
appointees will be
training
there
2
for
months in a
the
row.
September meeting.
I'm sorry?
The new appointees would be there for the September meeting.
Yes.
Yeah, all the commissioners that attend would be there for the September meeting.
They should be, yes.
Okay.
If you'd like, we could try and push it off till October, but again, trying to force them to be there or mandating that you be at this meeting. What we do is, I've got it marked on our calendar, I think, 2 weeks from now, you do new round of board appointments, and like I said, it's in August. So as soon as that list comes out, we get that contact. They'll get their standard letter from the clerk's office, but we usually try to get ahead of that, particularly for this August one, because we know we've got a September meeting, to reach out to them, let them know that they've been appointed, please see this.
Right, but for the commissioner who missed it last September, he owes you this education anyway. So he's 11 months late. He's not getting it a month early.
Right.
So he still has not satisfied last year's requirement because he missed the training then. So I'm just saying, bring him up to date.
So what I hear the board saying, or the commission saying, is that you would like us to pull that particular commissioner aside and make sure he gets ethics training
Yes, ma'am.
prior to his next attending a meeting.
Just to be clear, we're going to need that as a motion and a second and a vote, and I have a question for legal counsel, whether we have the authority to do that.
Should we hear that first then?
Well, you certainly have the ultimate, obviously you have the appointment role and the ultimate removal capability, should that be necessary. It would be unprecedented, but the logistical questions may affect that. Am I correct that in the annual meeting, you'll have the newly seated Planning Commission, and am I remembering, or would the plan be that would be in a study session format ahead of the actual meeting, so that if they had matters for consideration, they would have had that training?
Yes, we essentially do a pre-study session, so just like you guys meet at 2, and then you officially start your meeting at 4, we would then have them meet early, go through this standardized training that we provide that I think Dean talked about, goes over ethics, parliamentary procedure, all these kind of, some of the legal components of being a planning commissioner, and then they have their annual meeting. So they'll have had that training before they go into that meeting, which they elect officers and some of those other.
And it can be as simple as the conflict of interest, what is it, 8, 9 pages maybe? Just email it, hey, read this, please. I mean, at least some attempt's been made to make sure that he has officially seen it.
Well, and I think maybe that's where Mr. Scragg is getting down to a specific resolution, since I don't have something right now to say, thou shalt do, is having that direction from you that an email is enough, or that Mr. Bankston and I need to sit down and have a coaching session, or that I need to hold a public meeting in which we provide this training, again, the kind of level of what we're hoping to accomplish. And I think you've indicated timeline of before their next August business meeting is clear.
Well, that's August 4th, you said. Is when they meet.
Yes.
So that's next Thursday, right? Or
Next
Wednesday?
Tuesday.
Right, but I'm just saying,
Yeah, so.
there's an 8-page doc, I mean, he's going to read 150 pages for his meeting. So we're adding 8 pages to it, most of which he probably knows already, but just so that officially we know that he's seen it.
Do we need a motion just to send the ethics policy out with their packet?
I was going to ask one other logistical question, if I may. If Commissioner Davis, are you speaking specifically of Planning Commissioner Olson in your reference to him?
Or unless there's someone else who missed
Well,
the meeting.
the reason I asked that, in anticipation of my conversation with him, I forwarded a full copy of the ethics policy and the Planning Commission policy. So,
He has received.
and we talked, now I realize there's more to that than just the conflict of interest sections, but we did review those in some detail.
If
No, I don't want to.
No, I mean,
he may invite the opportunity to have further conversation with staff.
Right, but something like, but that would satisfy my desire that he certainly has been given the opportunity to have it in front of him and read it.
if your desire is for city staff to ensure that he has it and request that he reviews it before he participates further, I'm comfortable doing that at the staff level. If your intention is to preclude him from participating in future planning commission meetings until he meets some other standard, then we need to be more clear about the standard, and I'd like that to come from the governing body.
Your first option would satisfy my request.
But I think it does, it does kind of move, and this is obviously 10:25 at night is not the time to have this particular discussion, but I think we need to have it in the very near future that with certain boards, the imperative to know that backwards and forwards is so great that I think it needs to be a condition upon their active participation in a board is that they've gone through the training, so that the burden falls on us and it doesn't fall on Ms. Driscoll, who's saying, you have to do this, and she really doesn't have any authority or power behind her to ensure that that happens.
Recognizing that concern and desire, the model that I've been trying to build is something that is not in-person instruction, that if they miss it, they've missed the opportunity, trying to create something that is instructional, that puts the burden on each member. They review it, they confirm to us they've reviewed it, and so the burden is on them, and we have some confirmation that they've done that. With this attendance problem that we've had for years, we can conduct the training, but we don't get anything close to the saturation that we need. And it's a matter of convenience, it's a matter of attendance, we're not able to repeat it enough to get to the level that we want. That's why I'm trying to change the model.
Right, because tonight we witnessed what happens when that falls through, then you have mistrust in a public board.
Right.
Which then,
I completely understand.
Yeah.
I'm completely comfortable conveying the frustration, the concern, how much conversation we had at the staff level. If the expectation is beyond that, then I think the governing body needs to take action.
And we already do beyond that. Like, it's so, Dean and I are both very aware of how important and I completely agree with you, Commissioner Hodges, how important it is for them to have this training, that we take and go above and beyond. And we ask Mr. Bankston to come in quite often to do that meeting with us. And we have PowerPoints that we've developed over the years to make sure they get that, rather than waiting for something to come out, because we know that it's hard for them to do the hard work of making these decisions without that information. But I think it's really imperative. I think one of the things that I've taken away from this event is anyone who's put on these boards and commissions really needs to be aware of the independent expectation they have to share information in a timely manner. And that we can't do a complete background check on everybody. If you're not telling us something, we can't advise you or connect you to the right person. And I think that's important for them to remember. I think sometimes it's just, well, staff will get us that, or didn't staff know? No, if you don't tell us what your connections are, we can't possibly advise you any other way.
And just to clarify, when I said beyond that, I wasn't talking training. I just meant if your expectation was anything more than encourage them, providing the policy and encouraging them to review it in advance of the next meeting.
Yep.
But I think I understand you're comfortable with that, and
Right,
we can make that happen.
Really the only other option for us is to, issue some kind of reprimand or censure. And I think that the way Commissioner Davis is approaching it is probably a lot more positive in terms of coaching to try to achieve the behavior and compliance that you'd like to see, as opposed to punishing. And, with all due respect, obviously, the way we're doing it isn't cutting it. And I think maybe Mr. Scragg touched on that with, we need to find another way of doing it, because you can't provide 7 different orientations for 7 different commissioners. So, and if they miss the one opportunity, then we're 11 months in, and I hope he would have learned something from that, but who knows? So.
That was very well stated. Thank you.
Okay, I think you have the...
I think I do.
Okay.
If it helps at all, the next item could be postponed if you like. I think we can cover it in 15 minutes or less. So whatever is your preference.
Do it, yep.
Can we have about 4 or 5 minutes? 4, so...
Okay. You want it to delay the start by 5 minutes?
Yeah.
Okay.
Use a couple, well, 2, how about 2 or 3?
Okay. All right, that'll work. I move the city commission recess into executive session for 15 minutes to discuss the subject of the city's claim arising from the detection, isolation, and cleanup of asbestos materials in the basement and basement stairwell of Fire Station Number 2 with the city's legal counsel, based upon the need for consultation with an attorney for the public body, which would be deemed privileged in the attorney-client relationship pursuant to KSA 75-7319B2. There will be a 2-minute break before the start, so the open meeting will resume in this room at 10:45 p.m. and possible action to follow.
Second.
Got a motion, second, to move into executive session for 15 minutes. All in favor? Aye. Opposed? Okay, we are back in session, and there is no action to be taken. So unless anybody has a issue, we'll take a motion to adjourn.
So move.
Second.
All those in favor?
Aye.
Opposed? We are adjourned.